Ability.
Okay. Do you want me to go through, I don't know how much they want me to go through of the questioning. Do you want everything that I'm going to ask?
Well, you'll have to have enough evidence to
Well, under,
prove
yeah, just,
that it's admissible.
it doesn't have to be, it doesn't have to be a full-blown jury issue, but enough for me to determine whether or not it could be proved beyond a reasonable doubt.
We're going to, for purposes of the record, we're going to call you Billy. We're just going to use your first name, okay?
Yes, ma'am.
Can you
Okay.
move closer to the microphone? There you go.
Yeah, make sure you speak up. How do you know Tanner Horner?
I know Tanner Horner because my uncle had a baby with his mom, and I was raised as his cousin
And so how long have you known Tanner?
since I was 3 years old.
Was there a time when you lived on the same property as Tanner Horner?
Yes,
Do you recall about what time frame that was?
2000 to 2004.
And after, around that same time period of 2003, 2004, was there some type of sexual assault incident that happened to you?
Yes.
And can you tell us what that is?
It was a sexual assault down by Lake Worth Lake, right down the street from Tanner's grandmother's house.
And
Do I need to go into detail?
so, and that was, what location was that though, specifically?
Just to the right of the boat dock off into the trees right there.
And yeah, can you tell us, you don't have to give the full version, but what happened to you there?
He went back there, he pulled out his penis, he started masturbating. He told me to suck it, and then he grabbed my head and made me. And then he told me to bend over, he tried to put it in, it would not go in. And then he told me to continue sucking, and then he pulled out and finished by masturbating.
And did you tell Tanner no, or did you go along with it? What happened?
I was scared of Tanner. He was bigger than me, he's beaten me up before. I went along with it.
And after that point, was there a different incident that happened to you?
It was later on around 2007 when Paranormal Activity first movie came out. Woke up to him masturbating above my head. He pretended that he was asleep. I moved out the way, yelled several times, and he just kept on doing it. And then I waited till he went back to bed, and I laid down and went back to bed.
After these incidents, did you ever hang out with Tanner and one of his best friends, Cody?
Yes,
And can you recall anything about that event?
it was 4th of July. Tanner's grandmother had parked her van at the fireworks stand. It ran out of gas because I guess she was sitting on a hill. It wouldn't start. It rolled back. Cody gave us a ride home to his house, and in the car on the ride home, Tanner had mentioned he'd wondered what it would be like to kill somebody.
And how old were you about that time?
That time I was older. I was had to been 2008 or 9.
And so that first sexual assault was around 2003, 2004?
Mm-hmm.
And the second sexual assault was 2007?
Mm-hmm.
How old were you at those times?
2004, I would have been 10 years old.
And 2007?
Let's see. 13, 14, somewhere around there.
And then this other event was in 2009 when he made that comment.
Mm-hmm.
And how old, what is the age difference between you and Tanner Horner?
About 3 years.
Have you spoken to anybody about these sexual assault incidents before?
Yes, before the trial started, I spoke to the defense.
How many times?
Once she came out to our house. It was warm outside. I believe my kids had just started back to school. And she was in a white SUV, tan overcoat, and tan pants.
And did you have a phone call with anybody from the defense as well?
Yes, it was 2 to 3 weeks ago.
And in both of those conversations, what did you tell the defense? You don't have to go into detail, but
The first one, I told her about the sexual assault, and the second one was over the phone. She initially called my mom, and I told her about the sexual assault when I jumped on the phone with her.
that's witness judge.
Cross-examination.
Yes, Your Honor. Now, there were some different dates there when you were answering those questions. Can you help me out? In the notice we received, it talked about the first incident being between 2001 and 2003. Does that sound right?
2001, 2003 would have been when he set the hay bales on fire and started a fire in his backyard.
That's when you were living at Risinger Road.
Yes.
Okay, so this would have been after that when he moved back to Jackson.
Yes, around 2004 is when I moved off the farm. He was back at Jackie's.
Okay, and the second incident, is 2007 accurate for that?
Yes, it was the same year the paranormal activity came out because Melissa rented it from the Red Box.
Okay, so the 2004 incident, you two would have been what ages?
2004, I would have been 10 or 11. He would have been
12 or 13?
Yep.
And then the 2007, you'd have been 13 or 14, and he'd been 15, 16?
Yep.
Okay. And the statement about wondering what it'd be like to kill somebody, you said that was 2007?
That was around 2007, 2008.
Okay. So once again, he's 16-ish.
Yep.
Said a yes. Okay.
And did you speak to your mom or anyone else about this incident?
No, I never told my mom about the sexual assaults or any of that.
Okay. Now, when you say you spoke to the defense, you don't mean Susan, right?
No, over the phone call the second time, she named herself Shawnee.
And was your mom present for either of those conversations?
Yes, my mom was present for the phone call one, and my mom was present for the one where she showed up at her house. I just happened to be at my mom's house when she showed up.
And what made you decide to come forward now?
The fact that he killed a kid and the truth needs to be told. I talked to defense and I told them many times I wanted to speak to the prosecution, and they never got me in contact with the prosecution, so I posted on Facebook.
You said many times, you said you spoke to him twice?
When I spoke to the lady the first time, I told her I wanted to talk to the prosecution.
Okay.
She never got me in contact with them. When I spoke to Shawnee, I told her I wanted to talk to the prosecution. She never got me in contact with them. So I went to Facebook, and then the state contacted me off of Facebook.
Okay. You posted on Facebook, and then Ranger Espinoza called you, came to see you. What happened?
WFPD Wichita Falls Police Department left a card at my door, and I made the choice to make the phone call to Ranger Espinoza.
You're not pass the witness.
Redirect.
Nothing for the right now, Judge.
Any objections?
You're object on the grounds of that basically surprise, even the last supplemental information we had different dates than he's testifying to here today. This witness was not, we've had a long extended time to deal with extraneous acts. This witness was not noticed to us before the trial started.
Those objections are overruled. He'll be allowed to testify, and you may have a running objection to his testimony throughout his testimony. Both sides ready for the jury?
Ready, Judge.
Let's go. Just take a seat. All right, everyone may be seated. Ms. Dewell.
Thank you, Judge. Again, you can just use your first name, but can you introduce yourself to the jury?
My name is Billy.
And who do you currently live with?
Currently live with my wife, my mother-in-law, and my 3 kids.
And how are you related to Tanner Horner?
My uncle had a baby with his mother, and I was raised as his cousin
So how long have you known Tanner Horner then?
since about 3 years old.
And during your childhood, were you around Tanner Horner a lot or a little?
I was around him a lot.
And what did you guys do when you guys were around each other?
Usually playing, he liked to pretend play Dragon Ball Z, and it ended up him just beating us up. Throwing rocks in the rivers, creeks, out there on Risinger Road.
Was there a time when you guys lived on the same property?
Yes,
And what time period was that, roughly?
2000 to 2004.
After 2004, did you have any contact with Tanner Horner at that point?
Yes,
And where was Tanner Horner living at that time?
at Jackie's house in Lake Worth. Sorry.
What got you into contact with us, the state, in this case?
The fact that I told the defense I wanted to speak to the prosecution, and out of impulse, I made a Facebook post.
You made a Facebook post. When did you post that?
I posted that 2 to 3 weeks ago.
And what did you post?
It was a post about, let's see, Zero is fabricated, Tanner Horner sexually assaulted me, and basically beat me and Nicholas up as children.
And when did you meet with the state prosecution for the first time in this case? Roughly.
26 of last month.
So of April?
Yep.
From that Facebook post, you just mentioned that there was some type of a sexual assault. I'm going to ask you a few questions about that, okay?
Yes, ma'am.
All right. The event that you posted about, and you don't have to be exact on dates, okay? But do you know about when that first incident happened?
The first sexual assault?
Yes.
The first sexual assault happened right around 2004.
And where did that happen?
Down the street from Jackie's house, Lake Worth Lake, by the boat dock, off in the wooded area.
and you say from Jackie's house, how far away from Jackie's house is this boat dock?
Not even 5 to 10 minutes.
So how did y'all get there?
Walk.
So it's a 5-10 minute walk.
Mm-hmm.
Did you guys go there frequently before this, or have you been there before?
Yeah, me, him, and Nicholas would always go play at the park, go down to the lake, climb on the rocks and all that stuff. They had piles of sand out there. And then one day, Nicholas didn't want to go with us that day.
Now, how old are you at that time, and then how old is Tanner Horner at that time?
I would have been about 10. Tanner would have been about 13.
So Tanner Horner's about 3 years older than you.
Mm-hmm.
At this time, is Tanner bigger or smaller than you?
He was bigger than me.
Can you go ahead and tell the jury what happened on that day?
About the whole sexual assault.
Yes.
All right, it started off as we were all going to go play down at the park as usual. We ended up walking down the street. Tanner wanted to go to the boat dock. We ended up going off into a little wooded area of the boat dock. Tanner immediately pulled out his penis, started masturbating. He told me to get down and start sucking it. I was scared of Tanner at the time, so I did. And when a little bit of time goes by, he tells me to bend over. He tried to put it in. It would not fit, I guess. So he turned around and he had me suck it some more. And then he finished by masturbating next to the tree.
At this point, why were you scared of Tanner at that time?
Because he would like to pretend play Dragon Ball Z, which ended up him just beating us up and kneeing us in the stomach.
And
I was scared of him.
the us, was that his brother?
Mm-hmm.
Okay. Was there another sexual assault incident?
Yes.
And again, we're going to kind of, I know dates sometimes are, but do you recall the date on that sexual assault incident?
Same year Paranormal Activity came out, the very first one, 2007.
Okay.
He woke up to him masturbating above my head. He pretended like he was asleep. I backed off in the corner. He continued to act like he's asleep. Then he laid back down, covered up. And I just stayed there until I made sure he was asleep, and I went back to sleep.
Now, at this point, I think you were probably around 12, 13 years old,
Mm-hmm.
and with the 2007 incident.
Mm-hmm.
But yes.
Yes.
The court
Sorry.
reporter has to take down all your answers.
Sorry.
No, it's okay. So just say yes or no.
Yes, ma'am.
So after these two sexual assault incidents that happened to you, past when you were 13, did Tanner Horner ever sexually assault you again?
No, he didn't sexually assault me again.
Okay. After this point, though, did you still have some contact with Tanner Horner?
Yes, I got dropped over there to hang out with him. My parents were going through their own issues.
And was there an occasion where you hung out with Tanner and his friend Cody?
Mm-hmm.
And can you tell us about that?
No
Yeah.
objection, hearsay.
He hadn't testified as to anything said. Don't testify as to what other people told you. You could testify as to what happened.
Testify to what I heard, right?
Nope, can't do that. You can only testify as to what you saw.
I saw directly from Tanner.
Rephrase your question.
Can you, when you hung out with Tanner and his friend Cody, did Tanner Horner make a statement to you?
Yes.
Objection, hearsay.
Overruled.
And what did Tanner say?
Tanner said he wondered what it would be like to kill somebody.
How do you remember that statement?
But it triggered in my head when he actually did kill somebody.
And do you recall about when this happened?
It was 4th of July. It had to been After 2007, so about 8 or 9.
So 2008 or 2009? The sexual assaults that you posted about, and you just told us about, who else have you told about these?
I told
Objection, relevance.
Sustained. No, hold on. She'll ask you a question.
Now, Billy, in 2015, did you get arrested and ultimately convicted for a solicitation of prostitution charge?
yes.
That did not involve a child, though, did it?
No.
Have you ever kidnapped, sexually assaulted, or murdered a child?
Objection,
No.
relevance.
Sustained.
I'll pass witness, Judge.
Cross-examination.
Billy, I have a question for you. The school records show that Tanner moved back in with Jackie in 2002. Would that change the dates we're talking about for you?
I guess I'm going off my memory.
Okay. So if he was in the Azle School District in 2002, then we back those years up a couple years, would that still fit your memory? Would you may have been, what would that make you?
Maybe
8 or 9 and him 10,
probably, yeah.
something like that? 10, 11, something, 9, 10, something. Now, just a second here. Now, the second incident, when you two were teenagers, there was no physical contact?
No physical contact. Now, you said that you and Tanner, you're not blood relatives. You're related through his half-brother. Yep. Yes.
And your family and his family, before he moved back in with Jackie, rented houses on a farm,
Mm-hmm.
separate houses.
Yes.
So that's why you were around each other so much then.
Yes.
Now, at that time, when you and Tanner were forced to hang out a lot, were your parents struggling with an addiction?
Yes.
And Tanner's mother, and I guess her boyfriend at the time, your uncle, were they struggling with heroin and meth addiction?
Yes.
And did you tell, I guess you stated to Ranger Espinoza that Jackie was too busy dealing with those addictions to actually raise Tanner and his brother?
Yes.
Is that how you felt?
That's how I felt.
Did you and Tanner witness Tanner's mother chasing your uncle out of the house with a butcher knife?
Yes, it was me, Tanner, and Nicholas all put up a tent in the living room, and Melissa comes through chasing Eddie out the house with the butcher knife.
Okay, so
That
all
was
you saw
on
that.
Risinger Road.
And after that is when Tanner moved back in with his grandmother.
Mm-hmm.
Did they get evicted?
I'm assuming so, yes.
Now, in the time that you knew Tanner, was he ever depressed?
Not that I know of. He was just over energetic.
What about suicidal?
There was one time in my life when I stayed the night with him, and I woke up to Jackie taking him to the mental ward for a suicide attempt.
You remember, was that overdose or cutting? What was that?
I believe it was right after he got his shack, is the bedroom in the backyard.
Give me 1 second, Billy. I think you said that the last contact you had with Tanner was in 2018. You helped him get a job.
Yes, I got him a job at all my son's moving and storage.
Pass the witness, Your Honor.
Redirect.
Very briefly, Judge. Seems like the dates may be a little foggy, but is what Tanner Horner did to you, is that clear in your mind?
Yes,
Why come forward now?
I figured the truth needs to be told. He deserves to pay for everything that he's done.
Objection, Your Honor. Court's ruled on this in a motion limiting.
Sorry.
All right, sustained. The jury will disregard the last statement.
I'll pass the witness, Judge.
Mr. Goebel,
Nothing further, Your Honor.
may this witness be excused.
Yes, Your Honor.
Yes, Judge.
Thank you, sir. You go with the bailiff. I got to do one more thing outside your presence, okay? So let's take our afternoon break. I'll call you right back in. Short 7:05 hearing with the witness. So, Ms. Anderson, I'm going to let you go first.
Okay. Dr. Rambula, how are you?
I'm good. Thank you.
Dr. Rambula, have you received any additional records since we spoke, or actually since you wrote your report in April of 2026?
Yes.
What records have you received?
Numerous reports by your expert witnesses. Some of the notes, I didn't review all of them. The handwriting, I think, of Dr. Ryan was not as bad as mine, but I had trouble reading it. And then, let's see, I looked at the testimony from Cassie as well. And then I just listened to Billy's testimony today.
Did you listen to any of the experts who testified in this matter?
Briefly, there were two that I was able to follow about an hour each one.
Who was that?
The first one, I think it was Dr. Specht. I'm not sure. He was from A&M.
Dr. Edens?
That's it. That's him. Yes, sir. He might have been the first witness you had. And then briefly, Dr. Ryan last week sometime when she was on direct.
Okay. Based upon, and which, you said it was an interview of Cassie. Which interview?
It was actually not an interview. It was, I guess, court testimony from Cassie Wyatt.
Okay, do we know, was it her civil deposition? Was it the hearing that we had in this court? Which hearing are we talking about?
It was, as I put together, related to this case, so not the civil suit. I didn't know there was one.
Well, let me ask you this. If, when you looked at the transcript of that, were there lots of black lines on certain pages?
Yeah, there were some holes. I can't say that I remember big black lines standing out, but there were holes. That's the best what I remember.
Okay. What do you mean when you say holes?
In other words, it wasn't confluent. There were gaps, so to say.
So it wasn't the complete transcript?
It looked fairly complete except for maybe some omissions or things that were either not transcribed or something like that.
We had a hearing that began in December of 2025 and continued in April of 2026, wherein we discussed your testimony and your findings. Do you have any additional findings or conclusions in addition to the report that you've already produced?
Yes.
And what are those?
Based on me looking at the records again, I remember that hearing where I hadn't reviewed for that, and the expert reports, the transcript, the testimony today. I do have an opinion regarding future danger.
And what is that opinion?
That based on the evidence, there is a probability that Mr. Horner will commit violent acts and constitute and be a continuing threat to society. I think I'm paraphrasing the statute, but I don't remember it by heart.
What do you base that on?
On the statute. In other words, it has to do with the statute regarding future dangerousness in sentencing hearings.
I understand that, but I'm asking upon what evidence are you
Oh, I
basing
see.
your
Okay.
opinion that he constitutes a continuing threat?
So previously, I expressed concern about his temper, his ability to control himself, the outbursts he had. I think I mentioned his attitude towards women in general, based again on the audio recording that I listened to regarding his mistreatment of Athena. And then after looking at the rest of the reports that from the experts you provided, it was clear that he had some issues with executive dysfunction, difficulty with emotional processing, self-regulation, basically anger, so to say, and that he was also impulsive. And so because of their reports and the evidence they provided in those reports, coupled with my concern already about his ability to manage stress, control himself, his behavior, and particularly keeping in mind what I heard regarding what he did to Athena, that was the basis for my opinion.
Are you going to render an opinion on any particular diagnoses that you feel would be appropriate for Mr. Horner?
Well, if anyone asks me, sure.
What diagnoses
Okay.
do you feel would be applicable to Mr. Horner?
So based on let's see, let me state it this way. So when I submitted my report, I had reviewed records that covered approximately 20 years of his life, perhaps more than that. And based on that information, I rendered diagnoses of depression, anxiety, longstanding. I didn't point out in the previous hearing that per the records, major depression recurrent was something that came up, unspecified anxiety. There may have been some features of panic attacks, but nothing was really codified in a diagnosis. Additionally, and I think I stated in my report, I suspected that there were some traits of PTSD based on the sexual assault he endured as a kid that he didn't want to talk about, but I still nevertheless included it as a possibility, not necessarily a disorder per se. Based on the records I reviewed up to my report, the diagnosis of ASD had been, I guess, by testing closed, that door was closed, so to say. In other words, the two psychologists concluded he didn't have it. But after looking at the reports from your doctors, who probably see ASD a lot more than I do because they see kids, I didn't have any issues with that. At the time that I looked at the records and interviewed him, there was an uncertainty on my part about how restrictive and repetitive his behaviors were, his interests. And that's one of the components and the criteria for ASD. But I knew he had some social issues. I mean, he'd had that all his life. But you have to meet two, and that's why it looked like he didn't meet the criteria. But once again, your experts, I don't have any issue with their diagnoses because they collected a lot of evidence. I spoke about personality pathology. That remains the same. He has significant features of antisocial personality pathology. There may be some borderline personality pathology undercurrents in there as well, perhaps narcissistic, and that's about it. And lastly, after my evaluation, I was not very impressed with the amount of drugs that he had been using before. He rather minimized that, and so I took his word at face value. And I saw some inconsistency in the records regarding his drug use, but your experts, particularly Dr. Ryan, uncovered a lot of evidence that he was using drugs a lot more. So I didn't identify any particular drugs. I just knew that he was using marijuana, cocaine all of a sudden, and it looks like there were some hallucinogens as well.
What about paraphilic disorders?
The same. He has some features of sexual deviance, and I referred to that. That was based on what I listened to in the audio tape regarding what he did to Athena. And then this morning or this afternoon when I heard Billy talk about it, that would infer that there's been some aberrant sexual interests that have been longstanding.
So it's your opinion that if something happens when a child is 10, that can create a long-standing issue when that person is an adult and does something like this at the age of 30? Not
necessarily, but it's unusual for somebody to exploit somebody like that, particularly when there's a 3-year difference, the size is different. There's a lot of force involved. I had expressed some concern regarding how forceful he was during sexual activity with his peers, and that's normal as long as everybody's consenting. But there was a question about Cassie, saying not, I'm at to stop here, so he was perhaps pushing the limits more. And then when I read her transcript, she talked about some of the role playing that they did. In particular, what caught my eye was when they role played that he was her daddy and she was a little girl, which could very well resemble what happened between him and Athena.
But you would agree with me, though, that that's not terribly uncommon. I mean, we see movies back from the 60s and 50s talking where a woman is calling her paramour daddy.
Right. The role playing per se was consensual. It was like people explore, but I can't disregard the similarity between their role playing and then him acting out in a sexually deviant manner with Athena. And it's not unusual where that sometimes can occur when somebody acts sexually deviant towards another. You're right, it doesn't mean that it's going to happen, but those can be some warning signs when they show up in the records or somebody self-report.
And so you've read the records, you've read the reports from all of our experts, so you know that around the time that this happened with Billy, that Tanner himself had been sexually assaulted in a similar manner.
Yes.
And that wasn't of any significance when you looked at both of them?
The significance that to me was clinically apparent was the difference in ages. And when I say that, in other words, if Tanner had been at that age at whatever, 13, 12, whatever it was. 10, acting out with another 10-year-old or a friend from school, that happens. But when that type of activity occurs with somebody that doesn't want to participate, there's a big difference in size, between let's say a fifth grader versus an 8th or 9th grader. That's a pretty big difference in developmental years. So that is a bit different. I'm not saying that laid the groundwork for what he did, but I didn't disregard it, and it certainly caught my ear, given the types of individuals I've evaluated in my sexually violent predator hearings that I'm participating.
I'm sorry for interrupting. In this particular case, we're dealing with a 10-year-old and a 7-year-old.
Right.
So we're talking about two prepubescent children.
I understand that. Right.
Okay. You keep trying to put him in different grades. You'd agree with me that you're not going to find a 10-year-old in the 6th or 7th grade?
Probably not.
Okay. Have you made a diagnosis that Tanner meets the diagnostic criteria for any of the paraphilic disorders?
No.
Have you made a diagnosis that Tanner meets the criteria for antisocial personality disorder?
No.
So the only thing that you're here to testify to is that Tanner, based upon the records that you reviewed, that there's a probability that he would commit criminal acts of violence that would constitute a continuing threat to society.
That's my opinion. The change in my diagnosis was that based on the evidence your experts collected, I didn't have any issue with that.
With regards to the records that you reviewed, did you review all of the records from the Wise County Jail?
Not all of them, no.
What records did you review from the Wise County Jail?
Whatever was sent to me, so there were notations of incidents, like for instance, the suicide attempt. I reviewed that. There were some mental health records. I think it's Helen Therapy Center that provides mental health treatment to the detainees in jail. So I read all of those. If there's something else, then I didn't see that.
What about records from Tarrant County?
Yes, I saw those.
What records did you review from Tarrant County?
Up until, in other words, there were two periods when he was receiving treatment from Tarrant County MHMR. I want to say one was 16, something like that, and the other was more recent in 22, when he sought treatment again. Up until October was his last visit, I believe.
One moment. Dr. Rambula, just one last thing, and it had to do with the records. Did you receive any of the Tarrant County MHMR records from the state?
Yeah, they're listed in my report, and I haven't reviewed any subsequent records from Tarrant County MHMR.
Okay. Lost his, pardon me, Doc, I've lost your report amongst all my papers. Hold on one second.
Okay.
Do you have a supplement or an addendum to your report that includes all of the documents that you reviewed?
No.
I think that's it, Your Honor.
Mr. Berry?
Yes, Your Honor. Dr. Rambula, are you, in addition to the diagnosis that you've already stated in your report, and then just regarding the possibility of future danger, and in your questioning with Ms. Anderson, are you also going to offer, some characteristics that are found in both the paraphilic disorder and the personality pathology that you observe potentially with Tanner, whether or not he meets the full diagnosis, full criteria to be diagnosed with those disorders?
If asked that, yes, I can answer.
Your Honor, other than that, I don't have any further questions.
Any further questions?
No, Your Honor.
Dr. Arambula, if you'll go with Deputy King for just a few minutes, we'll call you right back in, okay? Any objections?
Yes, Your Honor. We don't have any objection to the doctor's qualifications. We know he's qualified. However, he has specifically stated that Tanner was not diagnosed with a paraphilic disorder, therefore it would be confusing to the jury to start talking about what symptoms there might be. If it wasn't diagnosed, it's not relevant. Same with anything with antisocial personality disorder. If we're talking about symptoms, it's not relevant because the doctor has already said that Tanner does not meet criteria for antisocial personality disorder. We also have a couple of other things with regards to Dr. Arambula. One is he's used the term sexual deviance. That's not a diagnosis for the DSM, and if he were to be able to use the term sexual deviance, again, it can confuse the jury. Same thing if he were to try to use the phrase psychopathology or psychopathy. He has done that in the past in previous trials, and so we would ask that he not be allowed to speak about psychopathy for several reasons. One, it's not a diagnosis, and two, if he's allowed to speak about that, then it could confuse the jury. And Your Honor, there is ample research that shows just how prejudicial calling somebody a psychopath or speaking of psychopathy is. In fact, the research has stated that it's almost as prejudicial as referring to someone as a pedophile. So we know that the research supports the prejudice that it causes, and so we're asking the court to order the witness to basically stick to the diagnoses that are in the DSM. The same thing with sociopathy. It just goes along with the line that it is not a diagnosis per the DSM, and allowing the doctor to speak in colloquialisms, one, is going to confuse them, and two, creates a false impression in their minds as to the symptoms that Tanner may or may not have, and three, is unduly prejudicial, and the prejudice clearly outweighs any probative effect.
Your objections are overruled. You may cross-examine him on those statements. Let's take 10 minutes. We'll start up at 10 minutes to 3.
Okay, well, I don't want to talk about the doctor right now. I want to talk about Billy.
Wow.
I mean, you guys were wondering about the look on our faces, and I don't know. Zeke, you're going to have to bring the camera up so they can see us, because the look on our faces was, I don't know about you, but both of us, Kevin and I, had our jaws just dropping.
Yeah.
We knew Billy was out there, right? Because I'd had people send me that Facebook post. We had heard that we thought this closed door hearing that they had was about Billy, and then we got Billy.
Yeah. Wow. I mean, just every single day when you think it can't get worse for the defense, and then Billy comes in, and wow, what he testified to and the details that he had in regards to that, which when you're judging someone's credibility, figuring out what things they remember about that. And I mean, he was very candid in some of the recollection of just even grandmother's tank was empty or had run out of gas, and areas over by the boat dock and how far
It had
of a
that
walk.
ring of truth, yeah.
Absolutely, and everything. So, and I mean, that's the thing. He was young at the age, so you don't expect them to know exactly what time and things of that sort.
Yeah,
but
you might
I mean,
be off by a year
yeah,
or
but
so.
he had some really specific details that only someone remembering that time frame.
Someone
you would think would
remembering something that's true.
Yeah. So I mean, I'm still. I thought we would get some sparks or find something out this afternoon. I mean, wow. I'm kind of speechless.
Maybe you think the jury's thinking.
Oh, I think they're speechless.
Like we are.
Yes. And I think they're like, oh my goodness. And clearly the judge is going to allow this in, as he mentioned, but I think, I mean, to me, what Dr. Ryan was saying in her testimony, I think she could have very well opened the door for this, just because she talked about him not being a pedophile. This other doctor talked about him not having criminal tendencies or being criminal in his conduct or in his actions prior to this. And I think that it's like they just kept ringing the bell, ringing the bell, ringing the bell.
And the judge is gonna let it in.
And they just kicked open the door, and now the judge, I mean, which he has every right to let this stuff in because it's rebuttal, and if they've opened the door and the state has information or evidence or witnesses that could shed some light or counter what was said, then and like I said, I think this is probably one of those deals that might have originally been kept out for the time being, but I definitely think that bell just kept getting rung, and I think now they're going to have to deal with what he says.
The consequences, absolutely. We're going to bring in Rebecca Lopez. Wow, Billy, that was something.
Yeah. Well, Tanya, this is expecting this because there was a hearing that was sealed by the judge. We didn't know for sure what that hearing was about, and the judge still can't say because that particular hearing was sealed, but it was, I believe, was about this particular witness and whether this witness would be allowed to testify because if you remember last week, we mentioned that there was a Facebook post out there that was floating around about someone accusing Tanner Horner of a bad act. And so now we know it was Billy and it was his Facebook post. And so the judge did allow it in rebuttal because they did open the door saying that he didn't have any tendencies of being a pedophile or had any other kind of criminal history or other prior acts. But then they bring forward this witness, which was, I was watching the jury. I was in there for that. And the jury just looked a little shocked. They didn't react. I think that they were all just trying to also keep their composure. Tanner Horner, though, was shaking his head and making a frown like, I don't know if he was trying, I couldn't really read what that meant, but either he didn't understand why Billy was testifying or that what Billy was saying may not have rung true to Tanner Horner, but he was like shaking his head and frowning when Billy was testifying at one point.
Kevin, what do you make of the thing where the cousin kept saying, well, I told the defense?
Yeah, now this is the thing, and this is what's interesting, is the prosecution, because they bear the burden, anything exculpatory or mitigating that would shed light for the defense, they have to turn that over. So if they talked to him and he said, Tanner's this great guy and he's done X, Y, and Z, then the prosecution would have to disclose that to the defense. Now the defense doesn't have an obligation because they don't have the burden to disclose anything that, and it's an ethical deal where they kind of have to balance that because you can't hurt your client. You have to advocate on behalf of them. So short of something that could get someone injured or killed, there's some parameters within that, but they don't have a duty to disclose that to the state because that's a witness that could potentially hurt them. Now, if they made any sort of representation, yeah, we're going to get you the state's information. And now that, even though they don't have the obligation to do that, I mean, as anyone, you don't want to mislead witnesses or lie to witnesses if that did happen. But in regards to their duty to disclose or turn that over to the state, they don't have that same duty in regards to that.
Right. I thought what his last statement when he says, I figure the truth needs to be told. He needs to pay for whatever he's done. And I understand the defense objected and the judge sustained it. But I was sitting there thinking, you cannot unring that bell. They heard what they heard.
Mm-hmm. Yeah. I'm still speechless in regards to just the depth of that one. I mean, man, my goodness. His family members, well, and I know he's semi-related, kind of cousin, or I know that, and I want to give Billy the benefit of the doubt just because I know Billy hated to just say that was my cousin. So whenever he was trying to diagram or say how he was related, I don't want to associate, and say, oh, that's his cousin. But it seems like anyone that's truly connected to him, and even in that familial line, they say something or there's information whenever they're just being truthful about some things, and it's not going good for Tanner for sure.
No, not at all. And having, Rebecca, you and I both know this, that having covered situations like this, it's actually not unusual for a kid like that not to come forward and also to continue to associate, right? To continue to, be with that person, your victimizer. It's not, it's actually not unusual at all. So, you can see how this kid, when this when Billy was a little kid. Here this is his relative, and he's slightly older than him. You can completely see how it could happen.
Yeah, I'd say that happens a majority of the time, more times than not, where the child holds on to the information or they don't disclose it. It didn't seem like this was a daily incident and things of that sort. So a lot of times if the family's having peace, or just imagine a young child that they don't want to be a disruptor or feel like they're going to get someone in trouble, they still might love the individual just because they've spent time, they've hung out, played with the individual. That's not uncommon for things like that, or people to hold on to that information and not disclose it immediately.
Yeah.
Well, and Tanya, he says that he was scared of him also, so, he had like this fear of Tanner. But also, Tanya, you and I have talked about this, that typically someone that does what Tanner Horner did, but something so horrendous, does not start off like that. There had to be some sort of prior history, and I'm surprised that they haven't had more psychologists that can talk about that. Maybe the prosecution, this rebuttal witness, will say something like that. Also, on this rebuttal witness, initially in the hearings that we had, he testified that he did not believe that Tanner Horner was autistic, but I do believe that he changed that. If you heard what we were hearing in the hearing, it says like, he went back and he read more notes from some more of the experts that the defense had, and he's kind of changing his testimony from what he testified during the hearings last week when we were having those the hearings before the jury got into the courtroom. So Tanya, looks like he's modifying his testimony a little bit.
Well, and when you get more information, that sometimes can happen. Well, Rebecca, we're going to let you go because Tanner Horner is back in the courtroom, and I expect that we're going to get underway with that expert witness. Thank you, Rebecca.
Okay.
Yeah, and Zeke, whenever the mics come up in the courtroom, just remember you can turn our mics off. Yeah, if you guys could have seen our faces first of all, when we were outside the presence, we kind of knew, we had a sense of what might be coming, but then when you heard the guy say it, and he's talking about it so matter-of-factly, right?
Yeah, I mean, and Tanya, you brought this up earlier in regards to when we were just talking off camera, the fact that this isn't anything that's fun for any young male to get up there and talk about someone doing this to them. And so the courage that he had to do that, I mean, that's one thing. But then also it rings true just even in that, because I'm sure that it's something that could be embarrassing to anyone to have to sit there and discuss and talk about something like what we heard being done to a young child.
Well, and he's a little boy, and this is his cousin that's doing this, and then it happens again a few years later, and as you get older, you say to yourself, well, why didn't I tell somebody? Why didn't I do this? Why didn't I do that? And there's a sense of shame.
Right.
You can just see that.
Yeah.
And that is the sad part, is that far too many children are sexually abused by people that they know, by people who have access to them.
Yep.
I mean, certainly what happened to Athena is awful and horrific, and words cannot even put them into expression, but your child is far more likely, you and I were talking about, far more likely to be assaulted or harmed by someone that they know.
Oh, absolutely.
Which is why, one of the reasons why we're talking about this, that, my son, he's now 14, when he was little, I was extremely cautious about where he could spend the night, who he could spend the night with, because I had covered far too many cases, and have known of people that this kind of stuff has happened to.
Yeah.
A cousin, an uncle, or somebody sexually abusing them. So.
Yeah, it's definitely one of those things that I think as a parent, anyone that spends time seeing things of this sort, you just, not that you have a distrust at all, but you're more on guard for the protection of your own family and your kids, just because you've seen from people that, most people think, oh, they'll never do this, or, oh, Billy's safe with this person, and it's just very sad.
It is sad. Mic's off? Zeke, are we back up in the courtroom? Okay.
All right, everyone may be seated. Ladies and gentlemen, this witness has been previously sworn to testify truthfully. Mr. Berry.
Thank you. Dr. Rambula, welcome. Will you please introduce yourself to the jury?
Sure. So my name is Dr. Michael Arambula.
And what do you do for a living, sir?
I'm a physician, a medical doctor.
And may I approach, Your Honor?
Yes, sir.
Dr. Rambula, as part of your involvement in this case, were you asked to provide a detail with your background and education and some other accomplishments as well?
Yes, sir.
And did you also, as a result of your evaluation of the defendant in this case, write a report?
Yes.
And did you also provide us with handwritten notes that you had made during that evaluation and after, in preparation for writing the report?
Yes.
At this time, Your Honor, I'll offer evidence State's Exhibit number 311, curriculum detail, State's Exhibit number 312, the report of Dr. Arambula, and State's Exhibit number 313, the handwritten notes of Dr. Arambula.
No objections.
State's Exhibits 311, 312, and 313 are admitted.
Dr. Arambula, I'm not going to take a whole lot of time going through your curriculum vitae, but can you give us sort of an abbreviated version of what your background is that qualifies you to make the diagnosis and opinions that you're going to give today?
Okay. So I'll make it quick. I attended the University of Texas at Austin and received 2 degrees from the College of Pharmacy. The first was a Bachelor of Science in Pharmacy, and then later I received a Doctor of Pharmacy. As far as why I'm a physician, I attended medical school at the Health Science Center in San Antonio, and I remained there for my internship and then residency training in general psychiatry. I completed that in the summer of '91, and then I spent a year in fellowship training, that's subspecialty training in forensic psychiatry in Chicago, and that was at Rush Presbyterian St. Luke's Medical Center. That was a year-long fellowship which I completed in the summer of '92. I've been back home ever since, and I'm also board certified in both general and forensic psychiatry.
So having this dual, you have 2 different medical doctor degrees, correct?
2 different doctorates, yes, sir.
Yes. So with regard to your work in this case, I just want to ask you how you became involved in this case to begin with.
What I vaguely remember is that you called my office, I think it was in probably January of 2023, and arranged to meet in my office to discuss this case, after which you retained me to work on this case alongside of you, looking at records and then ultimately evaluating Mr. Horner.
And are you paid for your services related to this case?
Yes, I am.
And what is the total amount of payment for services rendered so far?
So based on the last invoice that was sent, I believe it's $28,400, maybe a little bit more than 400.
Now tell us a little bit about your experience dealing with psychiatric patients.
Well, I've been in practice a long time, so as part of my residency training and then private practice, and I still have a private practice. I see predominantly outpatients. Collectively, I've seen thousands of patients who have different types of mental conditions. That's it in a nutshell.
Have you evaluated persons that have similar mental illness or / mental conditions that you have seen in the defendant in this case?
Yes, sir.
Have you also evaluated people that have different personality pathologies like you have seen in the defendant in this case?
Yes, I have.
And as far as criminal cases, kind of talk to the jury just real quick about what you do related to criminal cases.
Okay, so criminal case-wise, I've been in probably a few hundred criminal cases. And over my career, earlier in my career, I worked predominantly for defense, and then in the last probably 10, 11 years, predominantly for the state or the DA. I've evaluated individuals for competency to stand trial, for example, insanity, mitigation for like probation, sentencing, and I've done some evals for federal judges. A couple of federal judges asked me to evaluate someone representing both sides regarding their capacity to waive habeas corpus.
So with regard to this particular case, you said that you were asked to look over some records. Do you have a list of those records in your report?
Yes, sir.
Okay. And I'm not going to ask you to read those, but just so the jury knows, those are listed in your report on page 1. Is that correct?
Yes, and those are the records that I reviewed prior to and as a basis for the report that I submitted to you in April of this year.
And we're talking about April of 2026, correct?
Yes, sir.
So now, at that time, was that report rendering opinions and diagnosis based upon an evaluation that you did of the defendant?
The defendant and also the record review of Mr. Horner.
So with regard to the record review, I want to ask you some specific questions. At the time that you did the record review and also the evaluation of the defendant in this case, did you know at that time that he was going to plead guilty to the offense when it came time to go to trial?
No.
And does that create some limitations with regard to whether or not you can give a complete evaluation of the defendant regarding punishment special issues?
No, sir, because of the evaluation that I conducted, and before the evaluation I discussed with Mr. Horner that it would probably be related to guilt, innocence, and maybe sentencing after. So because of that informed consent, so to say, I collected information regarding both. I just didn't submit a sentencing report, so to say, because he hadn't pled guilty, or I didn't know what was going to happen, so I wasn't going to do that.
Understood. So the type of report that you did submit to the court was based upon your knowledge at the time, which was that he had not pled guilty. Is that correct?
Yes, sir.
And in fact, up until that time, pled not guilty. Is that right?
Right.
Now, what records, talking about the specific records that you reviewed, did you review audio and video recordings in this case?
Yes, sir.
And can you kind of talk about the kind of basic audio and video recordings that you reviewed in this case?
So the audio-video recordings were the investigative records, and that had to do basically with Mr. Horner riding in his FedEx truck before this crime. And then I also reviewed the audio and some of the visual of the day of the crime. When I say some, because there were times when he would cover up the lens with what looked to be a sticky. And then I also reviewed subsequent audio-video recordings after the crime.
With regard to
one more.
Pardon me. Sorry.
And then I looked at the audio-visual recordings of the detectives who were interviewing Mr. Horner afterwards, and I believe there were 2 of them.
And did you also have access to some sworn statements in the form of deposition or prior testimony in this case that you've had an opportunity to look at?
Yes.
And did that relate to persons that were family members or close associates with the defendant in this case?
Yes, sir.
And do you consider those to be collateral sources as far as your opinions go in your evaluation of the defendant?
Yes, they are.
Did you also have access to mental health, education, medical records of the defendant leading up to his arrest on December 2nd of 2022?
Yes, sir.
And are those also considered collateral sources that you used in making your diagnosis and opinions regarding the defendant in this case?
Yes, that's correct.
With regard to, are there a number of your findings in your original report that are based solely upon that documentation that you had had prior to that time?
Yes, that's the basis for my opinions.
Now, as far as the investigative agencies that you refer to, did you receive records from all the different agencies that were involved in the investigation and the apprehension of the investigation of the murder of Athena Presley Monroe Strand and the apprehension of the defendant in this case?
Yes, sir.
And did you also review some records related to prior sexual assault victims that came from the Fort Worth Police Department here in Tarrant County?
I did.
Are those also considered by you to be collateral sources which you use to render your opinions and make your diagnosis in this case?
Yes, sir.
Now let's talk about what were you asked to do pursuant to a court order by Judge Gallagher in this case?
Pursuant to that order, as best as I can remember, it was to conduct a mental health evaluation of Tanner Horner relative to the criminal proceedings going on at the time.
And at that time, you were focused on possible guilt of the defendant, is that correct?
Guilt, and well, it's not for me to determine, it's the jury, but yes, it was the guilt innocence phase of the trial.
And what date did that evaluation take place, or well, the interview take place upon?
It was February 27th of this year.
And where did that interview take place?
In this courtroom?
So here in this room, is that right?
Yes, sir.
And who all was present during that interview between you and the defendant?
So obviously, myself and Mr. Horner, there were three deputies, but they weren't standing next to us, but they were in the courtroom. And then Ms. Anderson came in and out periodically when Mr. Horner, we took a break so he could talk with her.
And so at that time, did you have a discussion at the beginning of that process with the defendant regarding the parameters of the interview you were conducting and what that information could be used for?
Yes, sir.
Could you kind of describe that for the jury, please?
So again, per my training, I do this with every case. I discuss who I am. I'm not here as a treatment provider. Who retained me? In this case, it was the state or the DA. That it was a court-ordered evaluation. There were a couple of guidelines associated with that because it's court-ordered. One is that the information we talk about may not be confidential, i.e. the judge wanted a report, and so I was going to put it in the report, and if it came down to me testifying, then again, the information would not be confidential. And then the second guideline in these kind of cases is that when I asked Mr. Horner something, he didn't have to answer it if he didn't want to.
And so were there some occasions where that actually happened?
Yes, there were.
So I'm going to kind of just have you tell me sort of in general about the level of cooperation that the defendant gave you during that interview for the evaluation.
So generally speaking, he was pretty cooperative. There were some areas that he was not cooperative with, and so we had to take a break. And then with each successive break, he became less cooperative and worked up, and so I didn't pursue the last time that he didn't want to talk about something. I just let it go.
And so if he didn't want to talk about something, did he avail himself of the opportunity to go and discuss it with his counsel during this time?
The last time...
Objection, Your Honor. May we approach?
Yeah.
Sure.
So it's, again, it's based on my training. I don't ask questions that might get somebody in trouble, for example. So I don't do that. And if somebody doesn't want to talk about suicidal ideation or drug history, it depends on whether that was important at the time of the offense. I can let it go. Sometimes I'll revisit it in case the person has a change of heart and may want to talk about it more. In some cases, when the refusal has to do with the mental state at the time of an offense, that's an important subject matter to cover. And so in that case, then I will ask the person to reconsider, which I did in this case. And then with further resistance, then I would suggest perhaps you might want to talk with your attorney.
Objection, Your Honor.
And then that's it.
Overruled.
And then I let it go with that. And if they decide not to talk about it, then at least I've given them, the option to talk with counsel.
All right, so let's talk about the fact, what is contained in your report. Can you just give us a brief synopsis of, not the details, but sort of the sections and how that report is set up, so if the jury wants to read through that report, they can do that.
So the way my report is arranged is I list the medical records first, and then I'll list a synopsis of my opinions. Okay? When you see the history section, that's based on the records that I reviewed. So there are no opinions or analysis in there. And then within that section, I will add the interview, because that's also part of the history. And then after that, then I go on to the discussion section. And that's where I repeat some of the findings in the history section, arrange them according to diagnosis that I've arrived at based on the records and his self-report. And then also my analysis of what's going on and how it relates to the offense, if at all. And then that's about it.
All right, so let's talk about your findings in this case. What opinions did you render as a result of your evaluation?
There's actually a typo here. There are 6. The first is he had a childhood history of abuse. That was in the records.
Okay, hold on. So childhood history of abuse, what abuse are you talking about there?
Abuse I used in a larger term. Growing up with his mother, no offense to his mom, was not so stable. So there was some abuse in the form of neglect, things like that. Her and her husband at the time were argumentative, likely domestic violence, what I remember at the records, those kind of things.
Okay. But as far as him being abused, other than this episode that's the sexual abuse that's been alleged, did you have any other specific incidents of him being abused during his childhood?
Just the abuse and neglect predominantly by his mom, and then the sexual abuse incident when he was around 10.
Okay. So with regard to him being involved in abusing other individuals, were you here for the testimony here, previous witness in this case?
Yes.
And is that consistent with other statements in the medical records related to his abuse of his brother as well?
Objection, Your Honor. May we approach?
There was a history of him having mixed symptoms of anxiety and depression.
Okay. And I think at some point you talked about possible PTSD symptoms, is that right?
Right.
And do you know whether or not he's been diagnosed with PTSD?
Based on the expert reports that I reviewed after I submitted my report, some of the experts arrived at a diagnosis of PTSD, some did not. Prior to my report, no, there was no diagnosis per se of PTSD.
So if you have an expert that said he tested him and he did not have PTSD, would that surprise you?
No.
Now, the next finding with regard to your report, what was that?
History of autism spectrum disorder, ASD.
And there's been a whole lot of testimony related to that. I don't want to go back into that specifically, but one of the things that is that you see with regard to autism spectrum disorder is resistance to change. Is that right? How would you say that?
That's one example, yes, sir.
Okay. Did you call it something called an order of sameness?
Yes.
Okay, can you explain that real quick?
For some individuals, not all, but it depends. They like everything the same, it's consistent, they repeat behaviors, that's one of the criteria over and over, along with that sameness. And then there's a rigidity, in other words, that things have to be the same or people become upset. Not everyone, but some people who have ASD.
Now, have you looked at the, you said that you reviewed the videos in this case, is that right?
Yes, sir.
With regard to the FedEx videos, were there multiple days which he was driving that were provided to you?
Yes.
With regard to the day of the offense itself, did you go over that thoroughly in conjunction with the transcript provided to you as well?
Yes, a few times.
And were you able to look at that transcript to determine whether or not what was said on those transcripts is things that you actually heard yourself on that?
I did hear them, yes.
Okay. And so with regard to what occurred in the particular video on the day, what we'll call the abduction video, did you see his ability to adapt to change based upon changing circumstances?
Yes.
Okay, can you kind of explain that to the jury, what you saw?
So after he initially abducted her and was not talking much with her, then he started asking her questions about her family, school, things like that. And it, at least by my observation, Athena seemed more calm by that. So that was an ability on his part to understand the situation, what was going on, and change his approach, as opposed to just picking her up and throwing her in the back of the truck. So that was something that I caught. And then under that immense stress of having started that crime, he was persistent in in his activities with her, basically.
And after the crime was committed and the body was disposed of, did you see his ability to change again?
Yes, as far as not being detected, covering up what he did, those kind of things, yes.
So were those things consistent with autism spectrum disorder or something else?
It was not consistent with somebody who wanted sameness, for example, or couldn't problem solve under that kind of stress. And again, my presumption, and he said it was stressful, that taking the life of a human being is stressful. Okay? So I didn't see him struggling with those kind of issues of lack of problem solving. He was still trying to go undetected.
Now, the next diagnosis, I believe, was a history of ADHD, is that right?
Yes, sir.
And with regard to the defendant's level of ADHD, was there anything debilitating about that with regard to him in this case?
Debilitating in the sense that he was socially a bit awkward, but that crosses over with ASD. So what I mean by that is kids who have ADHD, it's not unusual for them to be impatient and they kind of cut line, or somebody's talking and they interrupt, those kind of things. They might get on somebody's nerves because they're just throw themselves in. But as far grade-wise, he did actually pretty good. I looked at his transcripts. His IQ is average, so no intellectual deficits as a result of ADHD. But he was taking medicine, and it seemed like it was working to some degree as long as he took it.
So then the next thing that you say is a history of personality pathology.
Right.
And can you explain what that means to the jury?
Personality pathology is a broad term used to describe somebody who has had trouble interacting with others, basically.
All right. And are there different types of personality pathology?
Yes, sir.
And can you kind of tell the jury about that?
There are many. I'm not going to be long-winded here.
I don't want you to list every possibility, but are there some specific ones that you believe apply in this case?
So there's cluster A, which are the odd personality types. Yes, he has some of those, but he also has ASD. So per my training, I check the boxes on both and leave the doors open to see actually what happens with it. He's gotten into trouble here and there. He has really big issues with his temper. He's always had that, been physically destructive. So clearly there were issues with antisocial personality pathology, and again with ASD, because he has issues with controlling his temper, impulsivity, those kind of things. So I checked both of those boxes. He was sensitive to abandonment. Those were, if you remember, he attempted suicide after his girlfriend left him. And that's not unusual when somebody's overly sensitive to abandonment. I'm not minimizing what he was struggling with at the time. And that falls under a type of personality pathology called borderline. People with borderline pathology also have issues with anger management. They can't control themselves, and their relationships tend to be very unstable. A lot of arguing, instability, those kind of things. So there are many things that showed up in the history and in the records that I reviewed that I was checking both boxes. Some were ASD, and some were also personality pathology.
And did you also mention something called narcissistic personality?
Yes. Yes. Not, to some degree. In other words, he had, no offense to him, sometimes maybe an exaggerated opinion of himself, how popular he was, things like that. But not much more than that.
Now, your last finding, I think, is sort of the ultimate finding regarding the guilt portion of the case.
Right.
And what was that?
Basically, as a result of looking at all his history, he did not have a severe mental disease or defect, and therefore he would know that his conduct was wrong. In other words, he was not insane.
So, what experience do you have with dealing with sex offenders, and specifically sexually violent offenders or predators?
In a nutshell, a lot.
Can you just kind of just briefly tell the jury?
I'll keep it brief. So in my fellowship training is where I obtained my experience in evaluating and treating people who had sexual deviants / sex offenders. And that was in Chicago during my fellowship. And then when I returned home to Texas, our state enacted a commitment statute for sexually violent predators, which were the most dangerous repeat sex offenders who were about to be released from prison. And so we had hearings to commit them to treatment. And I've been involved with the state in those hearings for probably the last 25 years or so, hundreds of cases. That's why I said a lot.
You talk about in your report something called sexual deviance. Can you talk about that related to the defendant?
Okay, so sexual deviance in a broad term is an old classic medical term, and it basically correlates with a term you probably may have heard in this trial called paraphilia. And sexual deviance is basically when somebody has abnormal or pathologic sexual interests. And it largely has to do with individuals who don't give consent, so that's primarily children, adolescents, underage, and women who are sexually assaulted against their will. Or maybe somebody flashes somebody on a corner and the people around they didn't consent to that. So again, consent issues. There are less of a subset where if somebody is overdoing it in sexual activities that interfere with what they're doing the rest of their days, then that could fall under sexual deviance also.
All right, so talking about the evidence and the facts in this case, specifically related to the assault or kidnapping, sexual assault, torture, and murder of Athena Monroe Strand, do you see evidence of sexual deviance on the part of the defendant?
Yes.
Can you explain that for the jury?
So when I reviewed the audio recording, it was very clear to me that he abducted her primarily for sex. Because soon after he drove to the secluded spot that he had picked out, that's when he started engaging in sex with Athena. It's basically oral sex. He was teaching her how to do it, telling her what to do, threatening her, those kind of things. The things that I heard in audio recordings of victims in these cases, read about in investigative reviews of the victims in sexually violent predator hearings, all the same thing. So that's what stood out to me. So that's interest in sexual excitement with children is abnormal. And then the amount of suffering that Athena went through while he was victimizing her, that has some features of sadism. Sadism is where somebody either physically harms somebody or emotionally harms somebody, and it's part of the sexual experience. So there were two areas that caught my eye, looking through that interview and then correlating it with the transcript.
Now, were there other things other than just the facts of this case that indicated paraphilic features to you? As far as more than just the other evidence in this case, besides the kidnapping and murder?
So, to answer your question, interest, abnormal or pathologic sexual interest, they don't just show up all of a sudden like with kids. It's been brewing for some time. So I already knew that something had been going on. I didn't know why it was quiet, but something was going on, and that incident with Athena, it emerged. So that's the only thing I would add with that.
Well, you've also reviewed reports regarding the Tarrant County victims.
Oh, yes, I forgot about those, yes.
And also you heard the testimony just previous to yours. How does that influence you in those areas?
So, let's see. So those are, in other words, when there are other victims involved, and these are alleged victims, by the way, these are not convictions, that raises, for me, sexual versatility. So there are numerous outlets for sexual activity that are, and also, involving his wife and other women at the same time. So he has both features, but it's clearly versatility and increased sexual activity. Let's just call it that way. That's what drives the exploration and the versatility.
Can you look at page 4? Do you have your report in front of you?
I do.
Can you read it's the third, page 4, and it's the 1, 2, 3, 4, 5th full paragraph. And it starts about the third sentence down where it says he acknowledged the prior history of. And if you will continue that through the end of that paragraph. You see where I'm talking about?
Is that the first paragraph, Mr. Horner denied any history?
Yes.
Okay.
So, but just, I'm not worried about what he denied.
Okay.
I'm more worried about what he admitted to. So if you would start with, he acknowledged the prior history.
Okay, he acknowledged a prior history of sadomasochism and asphyxia, that's basically choking during sex, due to other women who encouraged him to participate.
Okay, so he's saying that he has been involved in, what is sadomasochism?
That's where the use of pain, the introduction of pain and humiliation into sexual activity for some individuals heightens sexual gratification. So spanking, hot wax, sometimes people use needles. Let's see, in his case, he reported inflicting cigarette burns during sex. So clearly, the experience of pain gets mixed in with sexual pleasure.
And then he also talked about asphyxia. What is asphyxia?
It's choking.
And you understand that he pled guilty to strangling and Athena and asphyxiating her.
Yes.
A person that does this in a sexual manner, do they normally do that to cause death?
In a normal manner?
No. If a person is doing these in a legal manner.
In a normal manner or legal manner, asphyxia does heighten sexual pleasure. Let's put it that way. As long as you can keep the person, in other words, you don't knock them out.
So
I'm not encouraging anyone to do that, but that's basically it in a nutshell.
okay, so he admitted to you that he had used choking during sex in the past. Is that right?
Yes.
Okay. Now, with regard to other sexual behaviors, did you listen to the testimony outside the presence of the jury of the previous hearing of his former girlfriend and mother of his child?
Yes.
And what, if any, testimony that she gave influenced you in this area?
What was added, listening to that, reading the testimony that was different in the records, or in other words, added to the records, was she just...
You're unable to object to hearsay?
Overruled. Go ahead.
Okay, I already knew about the issue of dominance. He liked to dominate her, he was rough. She had to set limits at times, but she consented to it until she said stop, and then he did. There was some role-playing involved as well. What they did participate in is him playing as if he was her father, her daddy, and she was his little girl or princess. And so they used to role-play like that as part of their sexual activity. There were ropes. She was not too excited about that and didn't want to participate. He had talked with her about hog tying her. She said no, those kind of things. So clearly he has an interest in things, but he abided by her refusals and didn't go further, but the interest was still there.
Now, with regard to the way that he talks to her on the video related to this idea of sadism, can you explain your opinions related to the things that were said by the defendant to Athena Strand during the time, between the time that he kidnapped her and the time that he ultimately killed her?
So what I heard were threats. If you scream or if you say anything, I will hurt you. Later it was, I will kill you. He often called her bitch when she came to, so to say. He was clearly very angry about that. I remember a comment, what part of shut up don't you get, bitch, those kind of things. So very degrading towards her after he had nearly beat her and strangled her to death.
Even as she is dying, does he make a statement to her about whether she's given up?
Right. Yes.
You
Like she didn't know when to give up.
The talk about Tanner's reasons. Did he explain to you his reasons for covering the front-facing camera during the interview?
With me, yes.
What did he say to you?
It was basically to cover up his drug use during work.
Now, since you have reviewed the videos, were there times where he was actively preparing and then smoking marijuana on those videos?
Using a vape, yes. A vape pen, yes.
And, but did you ever see any evidence of any type of cocaine use at all?
No.
With regard to premeditation, do you have an opinion about whether or not this was a premeditated act, not necessarily with regard to Athena herself, but with regard to a child on that day?
Based on the evidence, yes,
Your
I can
Honor,
answer that.
We object, may we approach?
Dr. Ramulett, you can answer the question as far
Okay.
as, other than just covering the front-facing videos, what other evidence did you review that makes you feel that this could have been premeditated act?
All right, so the word I use is planning, and that's what I'm looking for in my fellowship training. I remember in the investigative records that he'd gone to the site before he took Athena to the site, and that made sense because in the audio, he's telling her, okay, it's going to get a little bumpy now. So he knew where he was going. I asked him about why did you stop at that spot. He said it was secluded, so he obviously selected that. I talked about grooming earlier, when he changed how he was talking with her to help her calm down, to gain her trust, so to say, cooperation. That's what people who have some sexual deviance do to their victims before they exploit them. That's part of the planning as well. And then obviously walking her through what to do, how to do it, not to yell. That's all part of planning, okay, according to what he's thinking.
First thing that you said you visited the site. What site are you talking about?
The site where he stopped the FedEx truck, basically.
Where he turned off the engine
Yes, sir.
and sexually assaulted Athena Strand?
Yes.
He had visited that site previously to that?
That's what I recall in the records, yeah.
And with regard to his, does the fact that planning engaged in this and preparation, does that make it different from somebody that is just overreacting to something that happens in the spur of the moment?
Yes.
In what way?
So again, this per my training in evaluating individuals who are commit sexual offenses, most of the time there's planning involved, as opposed to if somebody just attacks somebody out of a bush. Okay, that's very impulsive, and that's a very different type of sex offender. Probably more, there's other things going on with that individual. So I'm trained to look for whether planning is present, grooming, those kind of things. That's why listening to the audio visual of the abduction made sense to me, that it was planned.
So I want to ask you ultimately, because your findings are laid out in your report, but the one finding that you were not asked to make has to do with the special issues for punishment in this case. Do you have an opinion as to whether or not the defendant, that there is a probability of the defendant committing criminal acts of violence in the future that would constitute a continuing threat to society?
Yes.
And can you explain what that opinion is?
Yes, based on the evidence that I've reviewed, it's my opinion that there's a probability Mr. Horner will commit future acts of violence and pose a continuing threat to society.
And is that true whether or not he is incarcerated for the remainder of his life?
Correct.
And can you explain that?
Okay, so not to rehash everything, but I'll just succinctly say he's had issues with controlling himself pretty much all his life for a number of reasons. That got worse as he got older. It culminated in this. Other experts have said he has issues with executive dysfunction, controlling his anger, emotional regulation, and impulsivity. That's all involved in this. So whether he's in prison, I've been in prison quite a number of times just to visit and interview people. It's like a little society, all right? So it doesn't really matter the setting, because he's going to come across in prison more or less people that he would probably come across in society. Because he has a mental health issue history, he's going to go to the clinics. There are techs there. They're almost, at least for me, my experience, most of them are females, techs, nurse practitioners, therapists, and there are female guards, of course. So it's a replica of our community, but it differs, obviously. The type of people that live there are also very aggressive, threatening. It's stressful, at least from the people I've talked to.
Now, I want to talk to you about incidents specific to you. You said that when you did your interview with the defendant, it was you, the defendant, and 3 guards in this room, correct?
Yes, sir.
Can you explain the situation that happened with regard to when you were questioning the defendant related to whether or not he sexually assaulted Athena Monroe Strand?
Okay. So that was towards the end of the interview, and he had been we'd taken some breaks because he didn't want to answer questions, and that's okay. But he was becoming a little bit more worked up, and this last question, I was looking at the transcript, and he was kind of critiquing me that transcript was the DA had made up, and it had inaccuracies and blah, 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 and he didn't do anything to Athena, et cetera, et cetera. And then I responded to him, I heard everything you told her. And it just stopped him. He was very upset. His stare went right through me. It took me aback because I wasn't expecting that. And then the rest of the interview, I didn't challenge him after that because I could sense his anger.
Was it incongruous with what you had up until that point?
Yeah, as I said, there was some increasing irritability when he refused to talk about certain subjects, and then he would come back and say, I needed a break. That's fine, I understand that. But this one was different. I was not expecting that type of anger from him.
Ask the witness.
Cross-examination.
Oh, yes. Dr. Rambula, we had a hearing back in December to discuss your review of the records and your opinions in this case. Is that correct?
Right.
And at that time, you had not evaluated Tanner Horner. So
Right.
you really didn't have a lot of opinions on that date, did you?
Right.
You had the opportunity to review all the records in this case, is that right?
Yes.
The records you reviewed, and I imagine you did a thorough review of the records, right?
Yes. I mean, let me add, there were a lot of Facebook posts, and some of them may have been years ago, and so I just kind of scanned them, for example.
So,
But I looked at them all. I just didn't spend a lot of time on some compared to others.
So you scrolled through all 10,000 pages of the Facebook records?
I didn't have 10,000 pages. I didn't count the Facebook posts, so I don't know how many there were.
Are these posts that were provided to you from the state?
Yes.
So they didn't provide you the entire 10,000 pages of the Facebook records?
I don't recall that there were 10,000 pages of Facebook posts. No.
So the state only provided you the posts that they wanted you to see?
No, not necessarily, because when I'm screening, when I'm going through the hard drive, portable hard drive, there may be some elements in the history that I print. I'm old-fashioned and I print stuff. And then other pages that I'm not going to print. And I decide that by looking at it. And so if it's just social commentary, things like that, I'm probably not going to print it.
All right, so you also did a thorough review of all the medical records in this case.
Yes.
And the records that you reviewed, I think you said were listed on your report.
Yes, ma'am.
So you looked at his mental health records.
I did.
You looked at his physical health records.
Yes.
You looked at the records from the sheriff's office in Wise County.
Investigative records, yes, ma'am.
And those investigative records, would that be the records related to the suicide attempt?
You mean the one in the jail? Or?
Yes.
Yes, I saw those records also.
So when we were here back in December, you hadn't evaluated him and you hadn't reviewed all the records. We had another hearing back in April of this year. Do you remember that?
Yes, ma'am.
And we asked you a lot of questions about the records you reviewed and about your opinions in the case. And you didn't update your report with any new opinions, did you?
I did not.
Did not issue any supplemental report.
Correct.
And you had over 4 weeks to do that.
Before the hearing, you mean?
From the hearing until now.
That's correct.
But you did amend it because you had some typos in there, right?
Yes.
And we're not going to hold those against you. We all
Okay.
do it. But you had the ability to amend your report.
To add to it, yes,
And-
covering the sentencing issues, yes, I could have done that at best, yes.
So you talked about the sources that you used, and I don't see a new list of records that you reviewed on your report.
Correct, because I hadn't received that list yet.
So you mentioned nothing in your report about deposition or the prior testimony of the mother of Tanner's child.
That's actually in the investigative records. I don't remember which law enforcement agency it was, but it was in that.
All right, so when you look at collateral sources, you would agree with me that collateral sources are an important source of information.
They typically are, it just depends.
And if there is an issue with inconsistency or inconclusions or poor historian, just with the person that you're evaluating, if it shows that they are a poor historian, isn't it important to go back and look at collateral sources to try to, either shore up what they're saying or disprove what they're saying?
In the instance where somebody doesn't remember something, then collateral information fills in the hole. If somebody misreports something or they exaggerate it or deny it, then if I obtain collateral information that, let's say, is hypothetically correct, I don't disregard what was told to me initially. In other words, they all coexist.
So let me ask you this. As a forensic psychiatrist, you typically don't administer any testing, do you?
That's correct.
But you do rely upon the reports of people who did administer the testing.
Yes, I do.
And you reviewed all of the reports from our doctors,
I did.
all the reports from our experts, and you had the complete file of the DA. Did you review all 40 hours of the video that was provided to you?
Probably.
How much do you charge an hour?
$3.50 an hour.
So if your bill is 28,400 divided by 350, that's about 81 hours you've put into this case so far?
Up to the time of the billing. I think the last bill was April, so it wouldn't include whatever I've done getting ready for this trial. And
Okay. Oh, sorry, go ahead.
I didn't review your experts, which took some time to read also.
So half the time that you spent preparing for this trial was watching the videos?
Most of it, yes, because like you said, it was close to, 30, 40 hours, so that was a long time. The records, no offense, some of them become redundant because they're different agencies and they're all there. And so I don't spend as much time when it's telling me that basically the record is telling me the same thing.
When you found out that Tanner had entered a plea of guilty in this case, that changed the focus of your testimony, is that correct?
I thought it would change the focus, yes, ma'am.
So your original focus, it appears, was to determine whether or not he was insane at the time of the commission of the offense.
Essentially that, or what mental state issues were at the time of the offense.
Are you familiar with the laws regarding the insanity defense in Texas?
I remember the basic verbiage.
So are you aware that in order to present such a defense, the defense would actually have to give the state notice that that was their intent?
That's been my experience. I'm not a lawyer, but it's been my experience, yes.
So in this particular case, to your knowledge, did the defense give the state notice that they were going to use the insanity defense? Or that we were going to use the insanity defense?
I did not know at the time, but again, this is guilt-innocence phase, and so that would infer to me that it could be insanity or something that affected specific intent. I didn't think that was involved in this type of case, but largely just mental health. I followed the judge's order looking at his mental health condition, and that's what I did.
Well, didn't you talk to the state before you came in for the interview and the evaluation?
Just where to meet, that's basically it.
So earlier you testified that Mr. Berry went to San Antonio to meet with you in your office about the case.
Right, I thought you meant a meeting before the evaluation of Mr. Horner, but no, I didn't talk with them about what I was going to do. It's just logistics, like what time, where do I go, those kind of things. The meeting, yes, that's when they retained me.
Okay, so that's what I'm getting at. So at the meeting where you were retained, they talked to you about what they wanted from you in this case?
As far as just looking at the records and providing my psychiatric analysis, that's it.
And that discussion took place in 2023 or When did that discussion take place?
February of 2023.
So from 2020, February of 2023?
Actually, I take it back, it was probably January of '23.
Okay. So from January of 2023 to February of 2026, you did not have any discussions with the prosecutors about this case and the direction it was going?
No, I met with them another time to go over my findings initially. I hadn't looked at the videos yet because that's a lot of time, and so they knew that. And basically, I was just looking at his mental health condition. I hadn't received the order yet, so I didn't know what the parameters were going to be.
Let's talk about the paraphilic disorders. Sexual deviance is not a diagnosis in the DSM-5, is it?
No.
You just use that for your testimony?
I use it
because of the
well,
historical significance of it?
right, because of historically that's been the term. The DSM is not the Bible, so to say. So if they switch it, that's fine. If you look up like literature searches, etc., loads of research regarding sexual deviance, very limited regarding paraphilia, as an example.
However, you would agree with me that the DSM-5 is a diagnostic tool for mental health evaluations,
Yes, it is.
and that sexual deviance does not appear as a diagnosis in the DSM-5.
It does not, no.
Would you agree with me that most of the people that have an atypical sexual interest do not have a mental disorder?
That do have or do not have?
Do not have a mental disorder?
If they have an atypical sexual interest or if they don't have one?
You would,
I lost you, sorry.
do most people with an atypical sexual interest have a mental disorder as well?
I can't say I've seen a lot of research on that because it's pretty vague, no offense, and gray. But that could be fair. I would say that, at least from my experience seeing patients, there's typically something involved, but it's not major, so to say. It just may be something that happened in their history such that it has some segue to what they are doing as an adult.
Okay, so we'll go back to the original question. You would agree with me that most people with an atypical sexual interest do not have a mental disorder?
I think that, again, there's not much research on it, but per my experience, I think that's fair to say they don't have a major mental disorder.
Because in order to have a paraphilic disorder, the diagnosis would require that that person feel personal distress about their interest and not merely distress from society's disapproval.
That sounds like one of the criteria, right?
And in order to have a diagnosis that it would require non-consensual engagement.
That's what I talked about, yes.
And so if someone is consensual and engages in these activities, that doesn't qualify as a paraphilic disorder, does it?
I agree.
You specifically mentioned that the interview and the testimony of Tanner's, or the mother of Tanner's children. Isn't it true that she consented to the behavior that you described?
I remember reading that, yes.
And when she became uncomfortable with anything, she took the initiative and she withdrew that consent, didn't she?
Yes, I spoke about that earlier.
And when that consent was withdrawn, Tanner stopped what he was doing.
Yes, same answer.
So he didn't continue against her will, did he?
No.
You mentioned sexual sadism in your direct examination, and you would agree with me that sexual sadism wasn't included in your report, was it, as a diagnosis?
I did not diagnose Tanner with pedophilia or sexual sadism.
And the reason that you did not diagnose it, I believe you had said that there was no diagnosis because of the one-time occurrence.
Correct.
Now, you're talking about the sexual sadism, and you're basing it solely on this offense. You said that you had talked about, the distress that you heard on the video.
So the video was probably the primary source, but it was not sole or by itself. There was other pertinent information. Why I talked about that earlier.
Well, there was no collateral evidence of sexual sadism, is there?
No, I didn't. I'm not referring to that. I'm referring to what's in the literature, and again, per my training in this subject matter.
Okay, so I'm going back to this case, not what's in the literature, but in this case, you were basing your decision and your opinion on the sexual sadism on something you could not see.
So one thing is, there are features of sadism, and it was something I did not see because he covered the lens, but I heard it.
And at the end of the day, again, you didn't diagnose Tanner with any sort of sexual sadism.
Correct.
You also did not diagnose Tanner with any sort of pedophilic disorder, did you?
Correct.
Because it did meet the criteria in the DSM.
Right.
You commented that things like this just don't show up.
Right.
So it sounds to me that you're basing your opinion on if he did it once, he must have done it at some other time without any evidence-based criteria there.
No, not using your verbiage, no.
So let me ask you this. You reviewed all the records, you looked at all the investigative, I'm sorry,
Okay.
investigative records from the district attorney, from the Texas Rangers, from the FBI, from Wise County Sheriff's Department. In any of the records that you reviewed, you didn't find any evidence of child pornography on any of his devices, did you?
That's correct.
And the things that you spoke about, the spanking, the hot wax, the needles, none of that's illegal, is it?
As long as they both involve consent to it.
You mentioned threesomes. That's not illegal, is it?
No? As long as there's consent between the three.
Asphyxia during sex. That's not illegal, is it? If there's consent?
Correct.
Role playing. That's not illegal, is it?
With consent, no. The same thing.
And you'd agree with me that it's not uncommon for couples to have pet names for each other?
No, it's not.
And so if I call my boyfriend baby, that doesn't necessarily mean I think he's a child in diapers, does it?
I hope not. No.
I hope not either. You also did not diagnose Tanner as a sexually violent predator, did you?
I did not.
Now, when you did talk to Tanner about what happened, about this offense, and about what was going on in his life leading up to this, you talked to him about the troubles that he had at home, didn't you?
Yes.
And he discussed with you that he was working long hours and that he was working 6 days a week?
Yes, we covered basically what his work days were like and what he had to do in preparation for each day, each route. Yes.
So we talked about the stress of not having reliable transportation and the change in his work route and things of that nature.
Yes, ma'am.
And he also told you that he covered the lens of the camera in the truck to hide his drug use.
Yes.
When the state asked you that, whether or not you saw any cocaine use in any of these videos, you said, no, I didn't. Well, let me ask you this. Is it possible that the cocaine use occurred after Tanner had covered the lens with the sticky?
That's what he said in the evaluation to me.
So you said you didn't see it, but is it possible that that's when it occurred?
Sure, like I said, that's when, in other words, I'm answering you using his self-report.
With regard to the planning of this, Tanner had been on that road before with his truck. Do you recall that?
Yes.
So it's not that, when you said that he had been there before, the way that it came out is that he went there to scout the place as a place to bring a victim. But that's not what was going on, was it? He had actually been there because that was the route that FedEx had sent him on to deliver packages.
I'm going to object that for that, Your Honor, it's a mistake.
I'll let him answer it if he can.
Well, he had been on those routes before, but I remember from the investigative records that before he abducted Athena, that he spent some time at that place where he drove back to.
What
So
records?
yes to both.
So what records are those?
There were some, it looked to me like FBI records where they were charting his movements based on cell phone pings and towers. It's way over my head.
Did you think to try to find collateral evidence that that may have been just his basic route? Or did you just take it at face value and make the assumption that that's why he had stopped there?
I just know that he stopped there before, and like I said before, he told me he had been on those routes before. So either way, he knew when to tell Athena it's going to get bumpy, because he had been there.
But that's not necessarily indicative of planning, is it?
Well, he knows where he's going. In other words, if he didn't know where he was going and it was just impulsive and he had no idea where he was, then he wouldn't know to forewarn her that it's going to get bumpy.
But again, that is not indicative of planning to abduct a child, is it?
Yeah, I looked at it as part of the abduction. As I stated earlier, the abduction was related to his sexual exploitation of her. That was very clear to me. And how he got there was just how he got there to where it was going to happen.
And that is just your opinion as to why this happened?
It's based on, well, it's not just my opinion, it's based on my training, the grooming behavior that he engaged with her. Per the audio, as soon as he turned off the truck, he went to the back, then take off your clothes, and then from there, it was one after another.
May I approach, Your Honor?
Yes.
Dr. Rangula, I'm going to have you look regard this FedEx Exhibit 312, to your report. Can you point out in your report where you talk about going on the bumpy road and planning this incident?
I don't remember actually doing that, no.
Okay, can you point out in your report where you talk about grooming?
I think the only thing I talked about was that this event didn't just show up out of nowhere. Again, this is during the guilt innocence phase, so it's different than what we're talking about today.
So planning would not be a part of the guilt innocence phase?
If it relates to the mental condition that he had and he was claiming confusion, then that would counter it, but that's not what he was claiming, so I didn't include it in my report.
So grooming wouldn't be relevant enough to include in your report?
I mean, I could have added that, sure.
But you chose not to.
Well, maybe I didn't just do it, but, yeah, looking at
Objection,
the...
Your Honor,
okay.
non-responsive.
Sustain.
All right.
I want to talk to you lastly about your opinion on future danger. You claim that you feel that Tanner will be a danger in prison because there are female guards.
Not
That's part of it.
as a potential component, yes.
So you review the records and you realize that, and you understand that Tanner has not had any disciplinary write-ups in Tarrant County.
I think, yes, that's correct. In his solo cell, he has not been a behavior problem.
And he did not have any disciplinary write-ups in Wise County either, did he?
I think there was only one time where he was put in a restraint chair that he pointed out to me, but other than that, no.
And he was put in a restraint chair because he was inflicting self-harm. Is that your recollection of it?
Vaguely. I don't remember the reason that he explained to me.
So that wasn't really a disciplinary, was it?
It's a form of disciplinary because the people can't just let him do what he's going to do, so they have to discipline him in some way so he won't hurt himself.
But
It's
he
not
wasn't
a form of discipline. It's more of behavior modification.
So he wasn't being aggressive towards anyone when that occurred, was he?
I don't remember that, no.
Now, when you're in a jail, you don't eat in your, you don't stay in your cell 24/7, do you?
Yeah. You mean if somebody's in general pub?
Let's say you're in SAG. You don't stay in your cell 24/7, do you?
No, there's some time out where a person is allowed outside. I think it may be an hour, maybe more, but I'm not the expert about jail stuff.
Okay, so, but you know that there are female guards in prison, right?
And jails, yes.
So you have guards in jail, you have guards in prison, you have access to medical unit, access to the transport people,
Right.
access to,
I'm going to object. Defense counsel testifying, first of all, and secondly, what the purpose of her being up there.
about to enter some records, Your Honor.
I'm assuming you were going to show him a record.
Yes.
Go ahead.
So, how many people in Wise County did Tanner attack?
I don't recall seeing any records of that, no.
How many people in Tarrant County has Tanner attacked?
Same reason. He's been in a solo cell and no acting out.
So you say he's been in a solo cell, but you do know that he has been going to the doctor,
Yes,
that he's been coming to court,
correct.
that in court you had other people with you in court. He didn't try to attack any of you.
No, he didn't attack me. He was just angry with me.
Your Honor, I'm going to offer defendant's exhibit number 93, which has already been tendered to, yeah, we just never offered it in evidence.
No objections.
Defense Exhibit 93 is admitted.
And Your Honor, we published to the jury.
That's fine.
And it requires, we just kind of call them evidence. Affidavit in the records.
Oh, you can file records with the court if there's what we call a business custodian gives an affidavit saying basically these are authentic records of our department, our business, or whatever. That's why they're called business records. And they are admissible without a sponsoring witness testifying. So you may accept what is contained in the records in the same manner had somebody been here to testify to them. Okay? Go ahead.
And explain what the affidavit
Yes.
is? Okay. What this affidavit is an affidavit of no records from Tarrant County, meaning that they searched their records and they could not find any record of any disciplinary action in Tarrant County. When people are in custody, Dr. Rambula, you said that, I believe you said that they had access to tablets. Was that you that testified to that? Or was
No.
that Mr. Fitzpatrick?
Yeah, that was the TDCJ
Okay,
guy.
I'm sorry. But you've been in the prisons, you've been in the jails before, is that right?
Yes?
So, you know, in talking to inmates, they just don't have to sit in their cells 24/7, do they?
Unless they're in solitary for some reason, yeah, and again, they get out, I think an hour a day, but otherwise, no, they can roam around.
So in their cells, do they have access to educational materials?
In jails, I haven't seen that as much. In prisons, depends on the unit.
As a part of the educational materials, or I should say as a part of what they can do in jail. And as I said, they have access to the educational materials. They can also do things like Bible study.
So that, my answers are based on what information I've learned from other people who are inmates, because I have no idea who makes, how TDCJ administration decides. I've just heard things from individuals. But yes, you're correct. There are some people who can, some cannot.
May I approach, Your Honor?
Yes.
Dr. Regula, I'm going to show you what has been marked as defendant's exhibit number 95, and we move to admit, I'll just go to 94 and 95, which had been previously tendered.
No objection.
So are there two exhibits, 94 and 95?
94 and 95, Your Honor.
Okay, no objection to either one.
Correct.
All right, defense exhibits 94 and 95 are admitted.
And Dr. Regula, you just made the comment that some can and some can't. do things in jail. In looking at Defense Exhibit number 95, are there a lot of certificates there for the things that Tanner did complete in jail?
It looks that way, yes.
And Your Honor, may I publish to the jury?
Yes.
All right, Your Honor, I'll pass the witness.
Redirect.
No further questions, Your Honor.
May Dr. Arambula be excused.
No objections.
He may be excused?
Yes, Your Honor.
Okay, thank you, doctor.
Just give us
State rests for both. Sanderson.
Defense rests.
State rests and close. State does. Defense rests and close.
Yes, Your Honor.
Okay. All right. There are a number of you who have not seen the last few exhibits, okay? What I'm gonna do is I'm gonna send you to your jury room with those exhibits so that y'all have a chance to look at them. And when everyone is finished, buzz. This will include all of the evidence that you're gonna hear in the case. You know what your instructions are for in the morning, okay? And we're gonna get started promptly in the morning. So after everybody finishes looking at the last two exhibits, it'll be regular time, 9 o'clock. Finish, looking at the exhibits, buzz, we'll bring those out, and then we'll get you home, okay? See you in the morning. All right, everyone may be seated. Both sides have requested closed. Ms. Anderson, it's my understanding the defense wishes to make some motions.
Yes, Your Honor. One was related to the jury charge.
Okay, we'll talk about that in just a minute.
Okay. The other one is related to our motion to preclude the death penalty because of the autism. When we initially argued the motion, I put all my arguments on the record, and we had held it to determine whether or not there were any valid diagnoses for autism. And so at this time, we would re-urge the motion and ask the judge to take judicial notice of all of the evidence that was presented by the defense witnesses related to the diagnosis of autism.
I'll take judicial notice as requested, and any other requests?
No.
Okay, those are denied. Now, that's the only other motion other than dealing with the jury charge.
I believe so. You're asking me as if I should have another one, but.
Just making sure. All right, let's talk about the jury charges. I have furnished charges, proposed charges, ad nauseam to everybody. The court's intention is to have two separate charges, one dealing with the issue of guilt, and then the second one regarding the issue of punishment. Is that agreeable with the state? Yes, sir. That's agreeable with the defense.
Yes, Your
All right, in regard to the guilt charge, are there any objections or specially requested charges on behalf of the state? No, Your Honor. Defense?
No, sir.
Okay. All right. The punishment charge. State have any objections or specially requested charges to the punishment charge as proposed? No. Defense?
Your Honor, we don't have any special charges. However, we do have I guess, a form issue rather than content. And that is, we wanted to move the verdict forms to, let's see, the verdict form on special issue number 1 to page number 3. And insert that and let the jury have the law related to special issue number 1, and then answer special issue number 1 before they move on to the law on special issue number 2. And then we would ask that the verdict form on special issue number 2 be moved to right behind that. And that we move all of the instructions to prior to special issue number 1. Did that make sense?
It does.
Okay.
The record should reflect that counsel, for both sides, have been very forthcoming with me in regard to their requests, and it's my understanding that that's why they do it in federal court.
That is correct, Your Honor.
But I am going to deny your request. Okay? Finally, it's my understanding, having had a conversation with the lawyers, that 1 hour for closing arguments on both sides is agreeable. Is that correct?
Yes.
Mr. State said he'll leave 20 minutes, that's all. So,
And before we break, may we approach?
yes.
heavily guarded when you are in segregation and special segregation and when you're on death row versus when you're in the general population. It's two different things completely.
And what Tanya said, going back to that in regards to what that doctor said, you know, he never pressed Tanner. It's one of those deals where he said, and that's okay, which I think given someone the benefit of that, and that's okay. He didn't want to answer this question. That happens. That's okay. But man, like you said, whenever he said, he just kind of stared right through me to the effect that this is a doctor that talks to numerous inmates, you could say, and based on the tone and how he said that caught his attention. To me, as a juror, I'm probably picking up that, man, this must have been something that really concerned the doctor to say, I don't want to press anymore because this guy may actually do something, grab me. I mean, who knows? But I think it's definitely one of those things that just spoke volumes and how the look, you could tell he knew what that look was.
That dead look, you can see that when you look, I forget which of the attorneys it was on, who, I can't remember if it was Terry or Jen Falk, who talked about just the cold look. And I understand that people are told not to show any emotion in court, but there's a certain look about this guy.
And if you look at Tanner, from the time Billy testified, when he came back in after they took that break and he came back in, the look that he had coming out of that, you could tell he did not look as this happy portrayed, happy-go-lucky or whatever it was that his attorneys told him, hey, you need to appear this way. He was not hiding his frustration or him being upset whenever he came out of that holdover before that last witness.
And then I think the other thing that stood out to me in the doctor was when he talked about the role playing with Cassie. I mean, holy cow. I mean, that's, first of all, that's sick, but it tells you something about the sort of proclivities that Tanner Horner has. Go ahead, Rebecca.
Well, and again, they don't bring Cassie to the stand, which is very telling. If all of this was consensual and everything that, why not bring her to the stand to say all of that, to bring her forward? But they don't call her to the stand. The defense doesn't. And then I also, again, just feel like Tanner Horner, you're right. His whole disposition changed. When I was watching Billy testify, you're absolutely right. He looked angry and he looked frustrated. And I go back to what the jury heard in that 1 hour long tape when he is killing Athena and telling her to shut up. He is screaming at this child with so much anger because she is dying and she won't be quiet. You cannot unhear that. So they can sit here and say, well, look at all these records in jail and the certificates he's completed because he's taken some courses in the jail. When the jury heard him screaming at this child, there's just no way that you can forget that, Tanya.
Right.
And he is angry and he is mad at this little girl who is dying.
And I think that they spent so much time, and whenever Cassie said that this was too far, he would immediately stop. And of course, a 7-year-old couldn't consent to anything.
Exactly.
It's almost appalling.
But she says no. And Athena's saying no to him. She's like, no, my mommy said not to do this.
Exactly, and that's the one thing I was going to get back to, and the fact that she's basically telling him no and begging, and in regards to him hurting her and having her do things and things of that sort. And it's just one of those deals, it's completely opposite of what the defense spent half of their time cross-examining this witness on, as though Tanner listens to this stuff. And the deal is clearly, and you heard that video, and you know what all was on there, but clearly this is an instance where he did whatever he wanted to do, and he showed very little empathy or sense of humanity in how he did it. And not only that, but Jingle Bell Rock. We will never, the fact that he could be so calloused and cold that's one of those things, like you said, the jury heard and saw all of this stuff. I think it's going to stick with them.
Well, you almost got the sense that the defense was trying to say, he only killed this one girl. And I'm just going, wait a minute, are you kidding me?
Yeah.
He just got the feeling like, he hasn't committed other violent acts that I'm just going, he kidnapped, sexually assaults, and kills a 7-year-old, folks. You don't have to do that multiple times. I mean, I don't know. I struggled with it.
Yeah, Tanya, I did too, because as we were both talking about, having covered a lot of these sexual predators and people like this back in, as we've covered a lot of trials, you don't just start off killing a 7-year-old girl. And the doctor says that. He testifies to that there has to be more in his history. And they're like, well, you didn't find pornography on his phone or child pornography on his phone. But that does not mean that there haven't been other attempts, because we know now that he tried to cover the camera a couple of times when he was out possibly scouting another child the day before. And we also don't know if he's just never been caught doing other things, and people haven't come forward, like the cousin who just came forward. There might be other people in his family that might have been assaulted, just never came forward like this cousin finally did.
Yeah, because that cousin's testimony, it felt true. Like the way he told the details, it's the details that somebody tells when it really happened. And he has nothing to gain. Nothing to gain. And he's a guy. Guys don't want to get up and do that kind of stuff in front of a courtroom of 40 or 50 people. Are you kidding me? And I understand that he's blurred for the live stream, but that's a hard thing to do. You do that because you think it's the right thing to do. And you do it because you want to make sure that, as he said right there in the end, that the right thing happens.
Yeah.
And I don't know if y'all caught this, but there's a point when they're asking the doctor, and they said, "Well, and the brother's assault," but then the defense cut him off real fast, and they said, "Can we approach?" But I think that they were also asking him about the brother being assaulted. I don't know if you guys caught that, but I caught it right away, and I said, "Wait, I thought they said it was the cousin," but clearly the prosecution asked about the brother.
Interesting.
And then
I did not
remember
catch that.
Remember the brother doesn't. Yes, and then the brother doesn't testify. Remember, the brother was going to testify, and they decide not to bring him up to the stand either, and he was set as a witness.
What do you think?
Yeah, that's just one of those. This is one of those onions that more and more gets peeled back. It's not going to surprise me of what else is out there. I mean, I think we're getting a small picture possibly of some of the stuff. But believe me, a long time ago, I learned that this case, there's nothing that's going to surprise me. And if we found out as something else later on down the road, I am not going to be surprised one bit,
Well, because and it wouldn't surprise me if Horner hadn't been sexually abused himself as a child. But that does not, because it's not unusual for prey to become predator. That does happen. But the idea that he just went from, what happened with the cousin allegedly, and then what happened with the two teenagers, and then there was a long stretch, right, between what happened with Athena, I don't buy that. There's got to be, there's other stuff out there. There's other stuff out there.
Yeah,
I agree, Tanya. And like this doctor said on the stand, he does not believe that this was something that was not a pattern, even though they weren't able to he wasn't able to diagnose him as a pedophile because they didn't find the child pornography and the criteria that you have to use, I guess, to actually diagnose someone with that. But still, I mean, you sexually assaulted a 7-year-old kid,
Exactly.
That's
exactly.
a pedophile.
One of the things that folks were asking in the chat, and it was kind of hard for us to hear back here, was what was the defense asking for right there at the end? In terms of, they were wanting hearings on autism. Did you catch that? What Susan Anderson
I
was
missed
asking
that,
for?
Tanya.
I think, and I'm
I
not
missed
sure,
it.
maybe in some of the pre-trial, I think they're trying to establish that because he has autism or documentation that basically the death penalty should be off the table. And I think that they're just re-urging motions, and maybe they had hearings in regards to this and made a record beforehand and had other additional documentation in regards to diagnosis. Because I know she'd mentioned something about medical records, and when she asked the court to take judicial notice, that normally just means that you're basically asking the court whatever's in the file or whatever has previously been admitted, or not even admitted, but just might be a part of the court record or the court file. You're asking the court to take judicial notice. It basically means we want this to be a part of the evidence, and so on appeal, it might not be something that went out to the jury, but it's a record of all of those documents that they may have wanted to present, because she also mentioned, and we want you to also take judicial notice of some of the prior arguments, but also documents that we were not able to get into or to provide to the members of the jury. And that's all just for record purposes, so that when an appellate court or someone else looks at this,
It's some
they'll
of the
know what's
housekeeping that happens.
Absolutely.
Because assuming he gets the death penalty, it will get an automatic appeal. That's going to happen. What was your sense of the demeanor of? Tell us about Athena's family, how they reacted to some of the testimony, some of the details that came out from Dr. Orambula.
They really haven't shown a lot of emotion at this point. I think that they already have heard some of this. The prosecution prepped this family prior to them being here. And again, we heard some of these details before in the hearing that we had. And she says back in April, which now seems forever ago, because it was like 4 or 5 weeks ago, when he came and the family was here when he testified the first time, when the jury wasn't here during the voir dire, when they were voir diring those witnesses. So they've heard this before, some of this before. So they were not surprised by any of the testimony today.
Okay. I'm going to start with you folks running. Sorry, let me talk. Some people have questions. Folks want you to explain, Kevin, what is a jury charge?
Okay, the jury charge, it's going to be a document that's going to have all of the elements of what the state has to prove. So it'll give the law, what the law is in regards to what the charge is. It'll also have what's called and it'll give definitions, so that if you see some word that's in the actual the language of the law, you have a key to go back to and see, okay, what's the legal definition for this, or what's the legal definition for that? If someone acts knowingly or recklessly or whatever, what are all those legal definitions? And then they'll have what's called an application, and it'll say, if you find on this particular day, and it'll give whatever's in the indictment that Tanner did, and then they'll just go through the language of everything, and then it'll give an instruction, you're to find him guilty of this said offense, basically. So all it is, that jury charge is just, it's the information that the jury needs, so that they know what the law is, how to apply the law to the set of facts, and then they're able to render their verdict. It'll tell them, if you find this, then you're to find this, and so that it just walks them through all of that. So as they're going through evidence, if they have questions, they can constantly go back. It goes back there with them, so they can go back and have that document and go through things whenever they have questions in regards to that.
Wow. Rebecca, do you have any sense on how lengthy the jury charge is? Have you seen it?
No, I haven't seen it, but the judge has said that each side was going to get an hour. If they start at 9 o'clock, and then each side gets an hour, and he's expecting it to go the jury to get this by 11 or 11:30, then it can't be that lengthy. And again, typically it's a lot longer when it's the guilt innocent phase, but we're in the punishment phase, so it's either life without parole or the death penalty. And I did hear him say, though, that prior to them hearing the closing arguments, he wants the jury to look at some of the exhibits to make sure that they have everything, and I think that they was going to have them do that prior to them coming out for closing arguments. So I'm thinking that we might get closing arguments a little bit later than we were expecting tomorrow morning.
And this also may be because I'm not sure that they've actually found him guilty. I know he's pled guilty, but the jury may be instructed, and that's not uncommon on a case where if they've already pled guilty, then they're going to get some sort of instruction to find him guilty.
That's what I heard.
And now you're to move on to the punishment phase, and then it'll let them know what they're to consider and things of that sort. So I think that we're probably going to see both of those. They're probably going to be instructed that they're to find him guilty based on his plea of guilty, and then to move on to that punishment. But Rebecca, like you said, the guilt innocence instruction is usually longer. It can be 7 pages, it can be 8 pages, sometimes even longer than that on a case like that, just depending on what other defenses. On something like this, you don't have all these lesser included offenses that might be if you have a murder, a manslaughter, criminal negligent, homicide, all of those things. Whereas this is probably going to be a pretty clean jury charge you would expect, but definitely on the punishment charge, those are shorter in general than the guilt innocence.
Okay. Hey, Rebecca, somebody wants to know, was that Ranger Espinoza sitting beside Athena's family in the courtroom? Do you know?
Yes, he's been here the last, he was here Thursday and Friday last week, and he was here this morning. I'm sorry, and he was here today, yeah. So he was here part of last week, and he was here today. That was him.
That seems pretty telling. I mean, I'm sure he has grown probably close to this family. I mean, you can imagine the personal connection he would feel to this case, and just the
And you have other law enforcement.
Go ahead.
Yeah, I'm sorry, Tanya. You have other law enforcement here that from Wise County that have been here also in the courtroom that were there initially as well. So you have other people from Wise County that have been in the courtroom that have also felt very attached to this case and to this family.
And people are asking in the chat, can the judge deny an appeal if there's a death penalty verdict? No, that appeal is automatic. So that will happen. That's part of the process here in the state of Texas. And somebody else was asking in the chat, because we have people, Rebecca, we have people watching from all over the world. And they wanted to know basically how lethal, I know it's amazing, how lethal injection, how executions are done in the state of Texas. And it's lethal injection here. And that process usually takes anywhere, that appellate process, 10, 15, sometimes 20 years. It just depends on how many issues are at play.
Yeah. And I think when Juan Sanchez was here, he said that this could go quicker just for the fact that they're not hashing out on the guilt innocence part. And I imagine that would be the case. Now the only question is going to be on how things were conducted on the punishment level.
Exactly. Rebecca, you got anything else you want to add?
Well, no, I was actually supposed to witness an execution here in the state of Texas last week, but I was up here for this. And so if people from all over the world want to know basically what happens during an execution, I mean, the families go in, there's this little window. It's not like a big room like you see in the movies. It's just a little window, and there's just only a limited amount of witnesses on each side. And then you can look through the window. By that point, the inmate has already been brought in, and they're already giving him meds that basically sedate them. And then they'll ask for final words, and if they want to say something, they can. And then there's usually a pastor or some sort of clergy in there with them. And then they start administering the lethal injections, and then they wait for a doctor to declare the person deceased. And typically that can be anywhere from minutes to, I've seen it be up to 20 minutes, because they have to wait for the heart to actually stop. And so they will have a doctor declare the time of death. And usually it's right at 6 o'clock is when they begin the executions here in Texas.
Yeah, and I've witnessed two myself, and it's very sterile. It's the best. I mean, it's a very methodical process. Sometimes, like I know the last one that I attended was a guy who killed a Dallas cop, a Dallas police officer, and the defendant's sister had to be taken out of the room. I was in the room with the victim's family, but she was, they were just on that wall over, and she became so hysterical that she had to be removed. So it's a weird feeling. It's hard to explain.
Oh yeah.
Yeah.
So, Rebecca, are there still protesters outside that courthouse wanting? Did you see any today?
I haven't seen any today. And there was really just that a couple of them earlier last week, but I have not seen them. I don't know. This courtroom is expected to be packed. It's a small courtroom, but I've heard from people that say they're coming down here because they want to be here. The judges is first come, first serve. And so it's going to be really tight and very crowded in that courtroom tomorrow, Tanya.
Okay, and then so we're expecting obviously closing arguments at 9 a.m., reading of the jury charge obviously, and then after they come back with the verdict, impact statements. And you've told us earlier that we'll be hearing from 2 members of Athena Strand's family. Anything else, Rebecca, from today that really stands out in your mind?
Well, I just, I thought it was also interesting some of the other rebuttal witness from the prosecution when they had the person from the Texas prison system come in and talk about how they have people that could be the DWI guy mixed in with a violent killer or a violent rapist, and that there's no difference, and that they have a lot more room to move around and versus what they do on death row. I thought that that was also very impactful when you're talking about future danger and who they have access to in a prison system. And we all know, look, Tanya, we've covered, I don't know if you remember Billy Shamirmir,
Oh,
who
yes.
was a
Serial
Billy
killer.
Shamirmir was a serial killer here in Texas. They did not give him the death penalty because the Dallas County DA did not seek the death penalty on him. So he got life in prison. And at the end of the day, Billy Shamirmir got shanked and killed in prison. It was a violent death, but he died in prison because someone had a knife that was smuggled in, or they made it. So it's not like there are no weapons in prison. And if you can't, keep your cool, and that's why the prosecution has been very effective in saying Tanner Corner can't keep his composure, he can't keep his cool, he loses his temper, is very critical to that question of does he pose a future danger. So I think what they're hoping to hang their hat on is the mitigating circumstance, and can you send an autistic person to prison or to death row rather.
Well, Rebecca, you brought up a good point, and one thing that stuck out from their expert, the state's last expert that testified, whenever he said, look, I've been down there, and when they go to these medical deals, a lot of times you're going to have female nurses in there. And thinking about the witness that you talked about, where they give their permission slip, they're unbound, they don't have handcuffs on necessarily, or leg shackles and things, and also saying that there's female staff workers there.
Right.
And so I think for me that was a big tell in regards to something that he testified to, that I think will just going to ring true to those jurors as well, is like, hey, if this guy just gets auto life and he's there without parole, he's going to have access to other individuals, other females, and we know so far it seems like whenever the opportunity arises, he sometimes takes advantage to his favor. So
Well, and it felt like what they did with that witness was actually turn the defense's arguments against them, in my mind, because of this whole thing about how impulsive he is, and he doesn't have good judgment, and his executive function is impaired, and yada yada yada. Well, I'm like, okay, well then maybe he needs to be in a nice, secure place like death row, where everything you do is closely monitored.
yeah.
So that's kind of how I took it.
Yeah, and I think the one thing, because I know a lot of times we think about that, but that's got to be in the back of the jurors' minds. I know they're not going to say, well, which facility or which location or where he's at is going to be in the best or the worst for him. They're going to answer those two questions on the future danger and is there any sort of mitigation to spare his life, basically. And so I think it's going to be interesting, but I can't imagine that those things that you said, Rebecca, what you've said, Tanya, aren't going to be in the back of their minds whenever they're making those judgment calls on the future danger aspect.
All right, we got a couple more questions. Rebecca, people want to know, what did you think of Billy, the cousin?
I thought he came off as very credible as well, but and Tanner Horner looked angry when he was watching him testify. He was like shaking his head. He was frowning. That's actually the most emotion I've seen out of Tanner Horner the entire trial, other than when Grandma took the stand, and he did look like he was a little emotional then, but he showed no emotion when we were listening to the hour-long tape of Athena dying, but he did look angry when his cousin was up there and almost like shaking his head like, oh, don't believe him. But the cousin to me came off very credible, because it does take a lot of courage to get up in front of a jury and in front of a courtroom and admit that you were sexually assaulted as a child. That is a very difficult thing for someone to get up there and do. But he felt like it was the right thing to do. And whether or not he had the right dates or he didn't have the right years, I mean, time has passed. But I thought that he had details that made him very credible.
Kevin?
Yeah, I agree with you. I mean, that was, had the state decided to even end with him, I would have thought, man, that's a strong witness to end on. Like I said, I think in them ending with the expert, from a standpoint of some of the things he was able to testify in regards to things that Tanner had told him.
Some things we had not heard
that we had
before.
not heard from. And also just the fact that he watched all of the video. All the defense's other experts usually is like, well, no, I stayed away from watching that, or I didn't ask him about what happened out there and everything. So I thought that finally the jury got to see what an expert witness from a standpoint of their demeanor probably should look like and how they should carry themselves, and I think that bode well for the state.
Absolutely. All right, Rebecca, we're going to wrap it up. Anything else you want to add?
No, I can see what happens tomorrow.
We've had surprises all throughout this trial, and I suspect that tomorrow we'll see more. I don't know what they'll be, but we'll see. All right, thank you so much, Rebecca. We appreciate you.
Thanks, Rebecca.
Thanks. All righty.
Okay, folks, we're going to wrap it up. I've been at work since 6 a.m. They had me in for daybreak, so my brain is, starting to get a little fried here. I get punchy the longer I'm up. But, kind of do what we often do, ending the day, talking about Kevin, I want you to sum up today. What did we see in here?
I think that we saw, one, how witnesses should conduct themselves whenever with opposing counsel. Two, I think that we saw, if there was a day of fireworks, this was the one, because just as if any jurors started to think, well, maybe this expert is saying some things that I agree with from the defense side, I absolutely think once they heard from Billy, I think that stuff went out the door. And I think it also is very telling the fact that I think that the defense's own witness opened that door up from what it seems like. But man, this was an interesting day. So I think the rebuttal witnesses came across really well. I think the classification officer,
he was on point.
He knew his stuff. And then I think the other expert knew what he was talking about, and he was willing to concede the times where he could have done something additional. And I think that's not something that we're used to seeing in this trial. We're used to seeing a little bit of more combativeness from some of the experts, and mainly it was from a few of the defense experts from last week.
Yeah, I liked him.
I did too. Yeah, I thought that he
and likability is not as big. Not to say that you can sway a jury with that, but if they don't like your experts and they don't like your defense attorneys, and of course we don't know how the jury feels, but that likability factor, it plays a role.
Yeah, it does. I think it goes strictly to the credibility. Credibility is everything, and I think that them being likable and also being able to answer questions and not seem to be combative in regards to that, or always on the defense, I think that goes a long, long way.
Absolutely. Hey, Zeke, you pulled this for me earlier. Athena Strand's mom, Maitland, has created a nonprofit to help raise money, and let me see if I can pull this up on my phone. Actually, Kevin's brother sent this to me, wanted to make sure that we mentioned it.
Yeah, it's Athena Strand's Army and everything, and so I think it'd be interesting just to get on and read about. I think it's AS Army.
Yeah, we're
gonna pull that.
I'm gonna pull it up on my phone. But anyway, at any rate, she's formed this, and she is. I have been so impressed by her strength. It's just amazing. And so this, I'm pulling it up. So it's 3 ways to serve. They're supporting families through tragic loss by providing comfort and financial assistance when it's needed most. They're supporting dreams through funding scholarships so that every child can pursue their dreams and become anything they hope to be. And child safety, they're advocating for the Athena Alert and supporting efforts to help find missing children across Texas and beyond.
It's great whenever you see something like this come about out of tragedy. If anything can be gained out of any of this that happened, it's good to see that maybe this prevents or helps out other people that may walk this road later on in the future, or that are walking through on that road right now.
Yeah, and
so.
it's a road no family wants to ever walk. So folks are asking if they can see Zeke. I don't know. We'll have to see if Zeke will be willing to come out tomorrow. You know, he's one of our directors. He's done a wonderful job throughout this entire trial. He also was the director during the Uvalde trial, and he works incredibly hard, and we really, really appreciate him. Hey, Zeke, can you put that link up real quick? Well, you know what?
There's just the asarmy.com.
asarmy.com. You see it, folks? Okay. All right. So I am really wrapping up. Okay. We are starting back up at 8:30 in the morning like we always do, because court's supposed to kick off at 9 a.m. They'll read the jury charge. We'll have closing arguments, and I will have Cody Skipper and Terry Bentley Hill will be our legal experts tomorrow. And my plan, as much as I can, is for us to stay live, with a break for lunch. So we're expecting closing arguments to wrap up around 11:15, 11:30, and then we'll talk for a while, and then we'll take a brief break for lunch, and then we will stay live as long as we possibly can until we get a verdict from this jury. And I would, if you were a betting man, would you say we get a verdict tomorrow?
I absolutely think you get a verdict tomorrow. I just don't see it taking them too long to come up with a verdict on this. But I mean, that's the hardest thing in this job, is trying to read a jury or know what they're going to do. But it won't surprise me if they're trying to send a message in regards to this. But I think that they may already know which way they're leaning after these 5 weeks of testimony.
Well, there has been so much. And even today, when we thought, again, I go back to I was on our daybreak show this morning at 6:30 in the morning, and one of the anchors asked me, well, do you think there'll be any more surprises today? And I said, based on what's happened so far in this trial, yeah, there'll be some surprises. I don't know what they're going to be, but we have seen those surprises. Of course, we had Billy's testimony, and then we had the testimony that came out during the Dr. Arambula's testimony, some of what happened, some additional detail of what happened in that delivery van, things we really don't want to know, but they're important for the jury to hear. So I will be back tomorrow at 8:30 a.m. and thank you for joining us.